Hey, we love that umbrella guy. All right. Thank you.
I'm calling from Los Angeles, and I'm having a little problem under the name ThatUmbrellaGuy. I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me. I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me. I'm a man.
Who's that face that's feeling you miss the most? It's that umbrella guy straight from the hat rack. Godzilla with cleats with the bass dropping impact. Cranking up the stylings in the syllable blender. Body bag, toe tag, return you to sender. Post that umbrella guy, your lyrical confessor. E-strap, flipped up, fully automatic microphone suppressor. Army of one, rolling through your silence. Pound for pound, unleash your rounds. See what buys are just my silence. Ghost riding the whip, the masked up live ender. Boxing up your threats and returning them to sender. Step into me, you better bring a nation as I wreck you to the population. It's that umbrella guy on the verbal flamethrower. Notching up the belt, not just some lame shower. Cranking up a stream just to show what's beneath. I'm masked up, baby, but I'm still sporting teeth. With one bling to rule them all and one bling to blind them. Iced out, grilled up, hunting knowing we'll find them. That E-homes are always flammable and will ignite you. Calling out the games you play just to spite you. I'm still standing.
All right, man, today, whoo, baby. What a day. What a day indeed. Can you believe it? Clayton won everything he could win. The only thing, I'm going to just spoiler and then we'll really get into it as we talk. The only thing he didn't, and people have talked about this saying, you know, well, it's a disappointment. Apparently the court they didn't have the jurisdiction to remove the protective order. So he didn't lose on the protective order. The judge just simply doesn't have the power or authority to remove it, but they would have. I mean, everything. Laura Owens is looking, next stop, the cops. Now, funny enough, you have Gingras out there being like, nobody's going to get prosecuted. And you know, as bad as he's been with everything else, yeah, I'd be really worried about it if he's out there saying that you're gonna dodge this. Yeah, he's been so right with everything else, right? Gingras, in fact, he's been pretty entertaining today. Let me pull this up. I'm gonna show you a few of his things. Oh, we're just gonna have fun today. It's gonna be good. I hope he writes a blog about this. I really do. I went in to write a blog about how wrong the judge was. Look at this, though. Somebody was like, if the DA charges your client, will you represent her? The DA isn't going to charge anyone. Really? Because they referred it to the cops, baby. They referred it to the cops. He's been so wrong on everything these days. It's funny, though. He's like, I'll release a longer statement later. I can't wait. Hey, wait, I haven't looked. Oh shit, is there a blog? I haven't even looked. Let me check. Let me just make sure. David Gingras. Is there a longer blog? Like, you know. Nope, not yet. Not that I know, unless he deleted it. No. I was just like, I didn't see one, but let me check again real quick. What a day, though, man. I mean, the best outcomes you can have here. And it hits there. By the way, thank you, AJ Stone, for the 10 gifted memberships. For some reason, again, the freaking, they've removed the super chat. Let's check this out. I'm going to show you this real quick. You know, to show you, this is, well, no, I can't make it lock out here. You have a tab where all the super chats come up. Like, you can show them like this, but if they've rolled by, you're supposed to have another tab that lets you bring up all the old stuff. And it doesn't. I'm manually hunting them. So here you go. AJ Stone, thank you for those 10 gifted memberships, by the way. Thank you. Also, Laura, thank you for the gifted membership too. Man, he's been having a fit about money too. So if you like our product and you want to support the channel, this one's on Gingras, right? He actually, it's funny. You want to see some funny stuff? Oh, man. Hey, Wendy, thanks for the 2. Tug, what about the bogus 911 and FBI? Hey, you know, with what she did, I mean, you know, where she called in the police to fake things. Here's the thing, though. I'm gonna be real with you. Female false accusers don't usually face justice, not real justice. She may, what you're really looking at, there's a lot of grounds for everyone else to look at this. People like Greg and Mike, you know, I want to look at Gillespie's case. By the way, Megan said that Gillespie, you know, threw props my way, and I appreciate that. You know, I feel bad for him and for Mike. I think they deserve justice as much as anyone else. They also came out there to speak, and they were robbed of their voice. So I really want to go over what happened with Greg Gillespie. I know he may not be able to speak, but by God, I can, you know? And anybody that wants to threaten, you know, a certain quote-unquote free speech lawyer that's been throwing out those threats, yeah, kind of hard to threaten when even the judge says. It's funny, by the way, free speech lawyer said that everybody's going to get sued into the ground, calling her a liar, right? Does that include the judge? You guys going to sue the judge too? I love it. Oh, I love today. Today's great. Oh, Mazza, thanks for the 10. Check the new People article. He makes a bad statement about the judge. Just came out. Oh, shit, really? Oh, God. Oh, man, today. Oh, you know what? Gingras is my favorite attorney. I'm going to say that right now. You know, and if you disagree, then... You think about it, like, this could have been so much worse, but Gingras motivated all these people to really come out there and really, you know, get going on it. So I appreciate Gingras for it, you know? Oh my God. Again, there's a People article, of course. Oh, now they have the stones to write an article, right? People does now. Now that it's easy. Now that people like freaking Dave Neal. Again, you know, I'm not trying to take any credit. Lots of people did lots of work. I'm just lucky to have a microphone. And I have a voice, and I get no, and I appreciate, like, again, Redditors did a lot of work there. Appreciate what you did. If I ever needed an article or some, you know, or rather not an article, but a court filing, or actually if there was an article or a Medium thing, TEDx or whatever, they were usually there. If they weren't there, you know, I could also Clayton's Justice, you know, but I could keep up with a lot of stuff through. Dave Neal was the one person that was right out in the front. You know, if there was hate going some way, of course there was Clayton, but outside of Clayton, there was Dave Neal. And all these mainstream places, they did nothing. Now that she's guilty, it's easy. Now they have the stones to speak up. You know, never let them forget that. They put out, you know, they want to cover when it's safe. but they never wanted to cover before. And yes, this stuff does need to be talked about. So I don't want to be a total ass and be like, I hate the mainstream press, honestly. You'll hear that from me a lot. I hate them because I feel like they're useless. But to get it out to everyone out there, I mean, you do have to tolerate them a little, I guess. But I'll look at that 1 second. I'm hitting a couple of these. Fallen Hero, by the way. What's up, Fallen Hero? How you doing? Thank you for the gifted membership. Appreciate you, too. Every day here. Appreciate you, man. Always here. Sandra D, too. Thank you for the gifted membership as well. Man, starting out big. Thank you. Love it. Appreciate it. I never want to minimize those either. You know, I mean, they're one of my favorite things. For real. So thank you. Shizzy Wiznut. What's up, Shizzy? Thanks for the 2. For Gangris's Venmo. Yeah, you know he was asking for Venmo donos. Did you know that? Did you guys see this? Okay, so check this shit out. 1 second. So he starts out the day really salty. I mean, it's very salty. And I got a good laugh out of this because he was whining that people would make money off of this. Oh my God, there's money being made. How dare people? Is the ruling really not public? It should be available online. Maybe I should emulate Clayton Echard's fans. They always minimize you, by the way. You're a fan. You know, we're all fans, baby. Okay. Whatever you say, baby. But and beg for super chat tips to post it. Now that's beyond sleazy. Even for me. So he admits he's sleazy. Like, that's an amazing thing. He's like, that's sleazy, but that's a little bit more sleazy than I am. I mean, you gotta admit, that's pretty amazing. Then he puts up his Venmo. He's like, despite what you think, I really try to take the high road. I really do, seriously. But I'll go ahead and take a walk on the other side once. First $50 Venmo donation gets the ruling. All proceedings donated to charity. And then, after, like, what, 3 to 5 minutes, somewhere in there, I mean, it took a little bit of time. Then he was like, that, by the way, that was sarcasm. I wasn't really asking for money. And it's like, sure you weren't. You didn't get paid? Did you get paid by the ruling, baby? Because this went sideways. I mean, this ruling is as bad as it can get. We will look at the People article after we look at this ruling, and you will enjoy it. If you have not seen this ruling, even if you have, come and laugh. Come and laugh, because this will be a good one. So, here's our ruling. And again, for anybody who has not caught this, if you catch this in the background, this is a false accusation case. There are many types of false accusations out there. One of the things that drives me absolutely bonkers are false accusations. You know, if you have somebody that's threatening to falsely accuse you, record them. I don't care who they are. I don't care, you know, if it's a crazy or your best friend, you know, or a spouse or, you know, whatever, you know, anybody out there. They threaten to falsely accuse you, record it. Keep good records. Clayton Echard did. And it paid off. And when people look at this and they complain, because they will, ultimately, they'll whine about how people, they don't want to listen to survivors. And it is unfortunate. But you know why? When I say they whine, you know why? Because they don't blame the right people. They blame people like you or me. And they should be blaming the people that caused this. People like Laura Owens that are court certified false accusers. So, under advisement. Oh man, this is going to be crazy. Okay, so let's get this through. All right, under advisement ruling, you say. An in-person evidentiary hearing was heard on June 10th. If you haven't watched that, you definitely should. I've got a live stream of it. A lot of people do. You can watch it. Shizzy Wiznut actually cleaned up the audio and everything, so you can watch the original or you can watch the cleaned up version. I would recommend cleaned up version. I want to give love to the original channels, of course, that picked up everything. You know, I want to give love to everyone that did this. Like I said, But if you want to really hear what happened, you need cleaned up audio to hear what's being said by Clayton Echard's lawyers. And all of it gets brought up in this. But June 10th, regarding the issues of sanctions, paternity, attorney fees, and costs. Everything. I mean, this is something else. So, jurisdictional findings. The court finds at the time this action was commenced, at least one of the parties was domiciled in the state of Arizona. Said domicile had been maintained 90 days, no minor children. There are no minor children. Okay, yep. Never were. That's what the court's going to tell us. Now, they give us a breakdown, and it's a pretty good breakdown. There are a couple of little items, like some dates or stuff, but this happens. You got to remember, all of this has to be pulled up. So, Laura Owens, the petitioner, she files a pro per petition to establish paternity, legal decision-making, parenting time, child support on date. Just ignore that, okay? But that's what she does. She files this pro per. Again. Then, petitioner files a motion to communicate, August 23rd. Motion to compel, August 29th. Expedited consideration request, motion to communicate, September the 4th. Expedited motion to seal, court record, September the 14th. All those motions were denied, by the way. All of it, okay? Clayton Echard, he would be the respondent, by the way. So you have, again, petitioner, respondent, files a pro per answer, 21st of August. The court granted respondent's motion to leave to amend response filed by counsel on December 12th, and amended response to petition to establish filings on January 26, 2024. The parties attended early resolution conference, September 28, 2023, wherein the parties entered into a Rule 69 agreement to comply with the RavGen DNA test. That's a weird... Rule 69. I was like, that has that has hidden meanings, right? I mean, people joke about that. Wait. It's a Rule 69 to get you to deal with something. Okay, that's interesting. Anyway, on October the 6th, petitioner files ex parte order of protection. After the hearing, order of protection is affirmed. Same day, RavGen results say little to no fetal DNA. October the 18th, petitioner filed a request for pre-decree mediation, citing respondent's unwillingness to communicate with petitioner and citing, quote, he even acts as if the unborn children don't exist despite a preponderance of the evidence. This is going to blow up in your face. On the 24th, the parties appear before Commissioner Typo. Gallica. What a name, man. In response to the injunction against harassment filed by respondent. On the parties' stipulation, the court previously reviewed both days of the hearing and identified that the petitioner, appearing virtually, frequently stood up and rubbed what appeared to be a swollen abdomen. We were talking about this earlier today, by the way. That sounds like it reminds me of a praying mantis. Something that, interestingly, like the description, I imagine Laura Owens as a praying mantis. She's got her little arms out there, rubbing along on her abdomen. These are things, by the way, that eat their mates. just to know. So, maybe that sounds like it would fit. I mean, what a fitting name. November the 2nd, testimony resumes. Petitioner testified she was 100%, 24 weeks pregnant with respondent's children. She further testified twins were due February 14, 2024. She testified that due to epilepsy, she was experiencing a high-risk pregnancy, being cared for by two specialists, Dr. McCool, Dr. Higley. She testified that she saw Dr. Higley last Friday. Now, this is something, again, this was brought up in the trial. The judge is catching on to quite a bit. You'll notice the judge paid attention and really caught everything that Laura Owens lied about. One of the things that Laura Owens tried to argue is she tried to say, no, I had an appointment with the person. But she didn't say that she had an appointment. She said that she saw the doctor. Big difference there. You know, if you cancel an appointment, you didn't see a doctor. You made an appointment. And of course she canceled, right? Of course she did. And again, the judge caught on to that. October 25th, the parties appeared before Commissioner Duda to determine the validity of the contested order of protection. Petitioner's abdomen again, it appears swollen. Again, remember all of this, considering what's being there. Like, this is why you get, spoiler alert, referred to the cops. Referred for prosecution, baby. I mean, that's as bad as it could go. During this hearing, she testified to the validity of the sonogram sent to the respondent, the media, and a Dropbox on Reddit, and further testified the parties were having a son. She later testified she believed they were having fraternal twins. One boy, one girl. Sorry, I hit my mic here. I was getting a drink and I hit it. I'm excited about this. This is so crazy. December 6th, second RavGen test comes in. Little to no fetal DNA. Third test was done. However, lost in transit. December the 12th, respondent files a notice of filing affidavit for non-paternity. December 28th, petitioner, that's Laura Owens, tries to get out of this because she knows this has gone bad. She files a motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support, with a notice requiring strict compliance with Arizona Rule of Evidence, thereby invoking ARFLP Rule 2A. Petitioner cited the basis for the dismissal is she's not now pregnant with respondent's children. The motion was denied as the issue of attorney's fees, costs, and sanctions still remained. On January the 2nd, petitioner files an expedited motion to quash deposition of petitioner. January the 3rd, respondent filed a response objection to petitioner's motion to dismiss. The court denied petitioner's motion to quash. Respondent withdrew his motion for sanctions pursuant to Rule 26 on the 3rd. Petitioner filed a motion for confidentiality, preliminary protective order on the 18th of January. Respondent participated in a deposition, February the 2nd. At a status conference, February the 21st, petitioner was ordered by the court to comply with Rule 49 disclosure requirements. During the hearing, petitioner's counsel advised that the petitioner had miscarried sometime in September or October. Petitioner was deposed March 1st, 2024. June 3rd, petitioner's prior counsel filed Ethical Rule 3.3, Notice of Candor, wherein counsel advises the court that statements made by counsel February 21st, 2024, status conference was factually incorrect. Specifically, counsel noted, Ms. Owens has not lied in the case. She has not intentionally lied to the court. While counsel believed the statements to be accurate at the time, counsel later determined those statements were not true based on petitioner's deposition. Voluminous additions, pretrial pleadings were filed by both parties. Those motions were ruled on separately by minute entry, and the rulings aren't relevant for the purpose of this hearing. So the finding of fact, this is where it gets fun. Now you are broken down. You know exactly what's here. Are you ready for this? This is going to be good. Let me get there. I'm feeling it. Here we go. Petitioner contacted respondent through LinkedIn. Petitioner and respondent, they met on May 17th to locate potential investment properties in Scottsdale. Petitioner has podcasts. Real estate investing company buys and sells horses. Between the 18th and the 20th of May, parties view some properties in Scottsdale. On the evening of the 20th, respondent invites petitioner over to his home, which she accepted. After petitioner arrived, respondent told her he was high on cannabis gummies, even offered her one, which she accepted. During the late evening of May 20th, 2023, and early morning of the 20th, 21st, essentially, both parties agreed that petitioner performed oral sex on respondent to completion twice. Petitioner testified she did not want to have sexual intercourse, but the respondent stuck it in briefly. Now she's gonna wreck her for this. Remember this, okay? This is going to get wrecked there, all right? Petitioner's implication that respondent initiated sexual intercourse without consent was not alleged initially in the court filings. It was not alleged until 2024. Holy shit. The judge caught that. The judge is like, wait a minute. That whole thing about him doing something involuntarily without consent, she launched that in 2024. Wonder why? At trial, petitioner testified that the parties had sexual intercourse and that it was ARP. So that's how the petitioner testified respondent was too high to remember the intercourse due to his voluntary intoxication. Now this, again, that being noted there, that's bad too. You know, if you're again, anybody who brings this case up, I hope you note this, and I want to note this again. He was too intoxicated by her. He says that he remembers everything. But her account is that he was too intoxicated to remember. So, if anybody got ARPed in this thing, it would be him. And remember, all of this is going to go sideways for her. Petitioner believes she became pregnant May 20th. She testified after May 20th, her menstrual period stopped and did not resume until November. Petitioner has had PCOS since the age of 17, did not have regular periods, has a history of epilepsy, testified she'd been pregnant 4 times. Each time the alleged father believed she fabricated a pregnancy and doctored medical evidence. So every I've been trying to fix this stupid thing. You know, it knocked me off there. I know. I don't know. Laura Owens, the devil. Sorry about that. I've been trying to fix it. There's nothing wrong with the... it took me 5 minutes to fix that. So I apologize. Yeah. Isn't that crazy? Isn't that absolutely whacked out? I appreciate 700 plus of you stayed around to see. It took me 5 minutes to get it right. There's no reason for it. There's no power outage. Like, check this shit out, for real. No power outage. No strikes. No nothing. Weird how when you start talking about false accuser females like this, you end up losing signal, isn't it? So strange how that stuff works. I mean, you start talking about these monsters, and then, you know, this has happened. This has happened multiple times. But with false accusers. It fucking fascinates me. And it irritates me, too. It's like, YouTube, are you trying to say something with that? Because like I said, there's no signal loss on my side. I actually check it with I check it with everything. I make sure that the the signal on the TV works. I make sure that everything, and I can't get back into StreamYards. And when I do, I can't make a connection stay. But it's only that. It's either StreamYards, but it's fascinating, like I say. That happened to me with the Depp trial, and it's happened with this one. Again, very, very strange, isn't it? You know? Anyway, we will pick up there. Like I gotta say, you know, what's really jacked up about it. Let me say this. People are often see, it's real easy to cover other stuff. It's easy to go out and say, look what Warner Brothers did here or that. And that stuff, you know, it equally has its point. I'm not talking smack about anybody that does that, because I do it too. I just haven't been motivated lately. I've been wanting to talk about this stuff. But when you talk about it, they demonetize all your streams. It feels like they try to shut you down on it because they don't want you talking about the truth of the matter here. And that's the fact that victims don't get the support that they deserve because of people like Laura Owens. Just straight up point blank. People like Laura Owens make people not want to showcase empathy. And it's an ugly side of all of this. Obviously, you don't need to listen and believe, but it goes beyond that. But anytime you talk about that, all these platforms try to fucking shut you down for it. Even so-called free speech. I mean, look at this. We're even being attacked right now by a free speech lawyer, a quote-unquote free speech lawyer. Free speech platforms try to shut you down. I mean, it's amazing, is it not? So anyway, let's get back to the document there. I appreciate you all. Like I said, you all waited around. You know, it does suck, though. Anytime we do this stuff, they throttle these kind of topics. I mean, it's just nuts. So anyway, sorry for my rant. I get so annoyed by it. All right, here we go. Let me reframe that. So we were on, from what I could tell, we were on page 4. You know. I don't know what part of page 4 we were on. Let's go with. We'll start right here. This is a good place to start right there. Okay. So with the petitioner saying that she had been pregnant 4 times, and each time the alleged father believed she fabricated the pregnancy and doctored medical records. Again, that's a fascinating statement to have in court record. It's just part of court record there. Talk about the properties that were available. They tried to purchase. Skipping forward there. Respondent prepared the purchase office, which petitioner signed her around the 24th. Respondent never submitted them to the seller's agent. Petitioner later asked respondent if he had anything from the seller in response to Laura's offer. Respondent advised he had not heard back from the seller. Petitioner testified that she advised the real estate board an action was taken May 31st. She says she takes a home pregnancy test, which shows a faint positive result. Again, faint positive. She says that she took more pregnancy tests. They all come back. She's triple pregnant. No. She says she's pregnant. She's so pregnant that she's triple pregnant. She denies using hormones, someone else's urine, or altering the test at all. Petitioner found respondent's reaction to be hostile and dismissive. On the 21st, she says she goes to Banner Urgent Care. She informs the nurse she believes she may be pregnant. She asks for a test to determine whether she was in fact pregnant. The test result says yes, she was tested positive for pregnancy. Again, urine test. Petitioner testified that for more than 6 months prior, she had not been sexually active with other men. Based on this, petitioner testified she believed she was pregnant and respondent was the only potential father. Now, here's a fascinating thing. Everybody's taking her word on this. You have to wonder. This is something that I have wondered for a long time. How does she select people? I mean, they all look the same, right? Like everybody, and I mean this in a very positive light, with Greg Gillespie, Mike Mancini, Clayton Echard. They're all big guys. They're all a tall glass of water, let's say. And she's very thirsty in the desert. I really want to make jokes about big gulps, but I run a professional podcast. Professional podcast. I mean, yes, I'm a professional. I will not make that joke. I would never make a joke about a big gulp. And tonsil babies. Oh, Lord. Never drink that. No, but it reminds me, like, when they're talking about this stuff, I mean, it's so strange. Like, to think, like, how does she select men? Is she waiting like 6 months to a year? Is she looking for that perfect person? They have to have certain clout, plus a certain bill. It's just so bizarre, you know? So anyway, the 19th, June, petitioner went to respondent's home at his request. Respondent provided a pregnancy test for her to take. Conflicting testimony makes it difficult to ascertain whether the test was taken in front of the respondent or with the bathroom door closed due to shy bladder. Both parties agree the test was positive. Now, this is fascinating to have in writing, period. Well, it's kind of hard to figure out exactly what happened there. Did she close the door? Didn't she close the door? It's just fascinating that that's there, period, right? Again, judge is writing up how this is put together. Now, this, the something to consider email. The court finds the language to imply respondent was attempting to buy into the idea that rubbing or grinding genitals together may have led to a pregnancy. The court, however, does not find the email conclusive that respondent believed her to be pregnant with children, but rather an attempt to consider her certain. So what she was saying, he's thinking about it. He's trying to figure out, well, maybe. You know, could that be right? Could it not be? And I like the way the court put that, because they're like, you know, when we look at this, we see him trying to figure out what's going on. That makes sense. The something to consider email. Respondent maintains the lack of sexual intercourse would preclude him from being the father of the fetuses. The email does not deny the pregnancy test was positive. In the email, respondent suggested that the positive test was the result of petitioner's epilepsy medication. Right there, they're saying in there, he says, okay, you got a pregnancy test positive there, but he didn't necessarily believe that, he questioned the validity of it. Because again, and she's going to point out that letter and what it says in it about, you know, tight. This will be forever document, by the way. Sorry, I got to light my cigar again. Oh, Lord. Petitioner emails Dr. something from Barrow Concussion Brain Injury Center, June 28th, 2023. The subject is pregnancy and seizure med. Petitioner denies sending respondent an ultrasound video, citing instead that Greg Gillespie hijacked into her email and sent the video to respondent. Now, what's going to be fascinating is there's going to be mention of these other people. Her being a serial faker. I'm telling you, the judge didn't buy into this in any way, shape, or form. Petitioner testified July the 2nd, 2023, she anonymously sought care at Planned Parenthood in L.A. While she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias, respondent presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up till today, she disclosed she sought care. You notice that? The judge pointed out straight up, point blank, hey, wait a minute. Up until today, she was saying that's where she sought care. So the judge, yeah, that didn't work out very well. The judge also points out LA, points out anonymous or under an alias. Again, judge was paying attention. That's something. And it gets worse. Worse for her. Petitioner testified that she had the sonogram at a Planned Parenthood in California, either anonymously or under a pseudonym, and changed the location to prevent the respondent from tracking down the records. The court was not provided with those records at trial. Wait a minute. Uh-oh. That's not good, is it? When they make a sentence telling you, wait a minute, all these records that you were supposed to present, by the way, they didn't turn them over. That's not good. If you're saying, and she did in the court, she said that my anonymity is more important than the court's order, essentially. Again, paraphrasing, but that's what she said. The petitioner testifies July 23rd. She experienced bleeding past two small fleshy objects, smaller in size than her hand. She took pictures of the tissue, sought telehealth assistance. This is going to come up again and again, too. Telehealth. Petitioner testified that she texted a miscarriage hotline. So she texts a hotline and sought telehealth assistance. The telehealth provider, again, telehealth provider, told petitioner it's hard to tell if she miscarried. She should monitor the situation and seek further care as needed. Petitioner chose not to seek in-person care that would have confirmed if she had been, still was, or had miscarried. The court, listen to this, the court finds the hard-to-tell component of the telehealth visit was due to the nature of telehealth and the inability to provide care in the form of an exam, HCG test, blood test, ultrasound, or sonogram. Oh, yeah. You know why? I mean, we do telehealth and in mental health practice alone, there are specific things like you don't use telehealth for. It just depends, you know? And if someone was saying they were having a reaction to something or they had a big question, it could be potentially dangerous. You would tell them, hey, you need to come in person. You need to go somewhere. See a provider. You would never tell them if there was a risk, especially, you know, again, we work with as part of that, we work with physical care nurses and nurse practitioners. You know, they're part of it. And many of the nurse practitioners are also their prior family care. Oftentimes we will pick up people that decide they're, they want to go into mental health for whatever reason, or they wanted to, they want to try both, or just whatever. But they'll talk about any instance, and one of the things that we have there, if somebody is high risk, if there is any risk to the client or any risk that involves any life whatsoever, you automatically refer. You see that everywhere. It's written into everything. You know, if you have an immediate need, you even question having an immediate need, go seek help immediately. But instead of seeking in-person care, she chose to take another HCG home pregnancy test, July 25th, which was positive. Petitioner again took a home test instead of seeking care, August 1st. Petitioner testified she made multiple appointments to see Dr. McCool. 3 of 4 appointments were rescheduled and then canceled when the petitioner tested positive for the beer bug. McCool's records indicate 44 pages of records confirming making and canceling appointments. The court was not provided with evidence of a positive beer bug test, but maintains that the nature of her high-risk pregnancy would warrant a visit to the ER, who would be equipped to care for a high-risk pregnancy wherein the mother was beer bug positive. And that's true, too. You know, that's something that doesn't get brought up a lot either. If she has the beer bug and she's high risk, wouldn't she have gone to the hospital? Wouldn't that alone be a reason to go and seek immediate assistance? Guess not, right? Well, the court's like, yeah, that would be. That would be indeed. August 2023, the parties agreed to a DNA test, the Ravgen. Petitioner pays $725 for the test, but respondent failed to provide a sample. Petitioner cancels the test August 18th. The court did not find sexual contact between petitioner and respondent resulted in a pregnancy. Did you read that? Did you hear that? I'll have to read that again. The court does not find the sexual contact between Clayton Echard and Laura Owens resulting in a pregnancy. The court finds that if the petitioner was pregnant, it is profoundly unlikely that conception occurred because of rubbing, grinding, and the dripulations. Yeah. During this litigation, if petitioner had maintained consistency, an allegation of SA, coupled with a police report or physical exam, the court may find differently. Evidence and testimony, however, do not support this inconsistent contention. There was no SA. They say that right there. No SA. He did not do it. The court is saying if she would have been consistent with that, if she would have alleged it from the beginning, if there would have been some kind of report, if there would have been anything, but the judge notes that from the beginning of this, that wasn't alleged. It wasn't alleged until 2024. That's when that allegation came up. And the judge put that in there. So again, the judge made it straight up. You know what, too? Laura Owens, lying about that, you fucking scumbag. That is life ruination tactics. You are the worst of the worst. That isn't out there like saying somebody stole a cookie from the cookie jar or something. You know, this isn't alleging some kind of a false pregnancy and a loss, which is horrible in its own right. But this right here, this goes beyond. And remember, the allegation she was already making was that he was an absentee father. He was a deadbeat dad. He didn't want to take care of his children. That was already the allegations. But that wasn't enough. She had to fucking ruin him because he would not take a dating contract. That is a fucking horrible person. They deserve to be prosecuted. In September, October, both parties submit samples to Ravgen. October 16th, blood was drawn. Results, HCG levels, 102. Petitioner changed the results to reflect 102,000. Oh, I only sent that to Dave Neal. That's not what the court found, baby. The court says you changed that shit. Oopsie. Oops. Kinda got busted. Kinda got busted. Kinda got busted big time, right? You know, it's fascinating too. They kept saying, again, I want to go back to this. David Gingras kept saying that they were going to sue Dave Neal into homelessness. They were going to come after all of us because we called Laura Owens a liar. You going to sue the judge too, David? Is that what you plan on? Because the judge said you're a liar. You are a liar. She also brings up your hand signals, which is fascinating, you know? What's funny, too, is he was posting online about how you were allowed to do certain things. And then the decision comes in. I'll show you that after we read this. Petitioner testified that on October 18th, 2023, she was aware of the alleged pregnancies were not viable, filed the request for mediation in hopes that at mediation she could tell the respondent that the pregnancy was no longer viable. Upon denial of the request, however, she did not file a motion to dismiss or make other arrangements to advise the respondent of the development. So, her excuse here, again, it's saying, she says that during the mediation she was going to break the news. However, when that didn't happen, she didn't follow up. So, the court finds this testimony uncredible and a misuse of judicial resources. The court just said that Laura Owens is a liar and that she misused judicial resources, aka she weaponized the fucking judicial process trying to damage. Straight up. The judge just called her a liar. Just straight up. You were lying about that. You never planned on it. Petitioner was not treated by Dr. McCool or Dr. Higley, as she testified November the 2nd. Hearing on IAH. Petitioner's alleged pregnancy was not treated by Dr. McCool, Dr. Higley, any other in-person obstetrician, gynecologist. The court finds failure to seek in-person care for a high-risk pregnancy to be both unreasonable and uncreditable. Oh, you're high risk? You didn't go in and didn't get any treatment at all? That's unreasonable. That's what we've been saying forever. How does that work? Laura, how does that work? That's what the court would like to know. Why would you do that? Oh, well, maybe because you're a liar. The court further finds that going to Banner for pregnancy tests, but not the passage of fetal tissue, to be unreasonable and incredible. A reasonable person, if seeking emergency room care to confirm a pregnancy, would not rely on telehealth to confirm the non-viability of the pregnancies. Boom. A reasonable person wouldn't call in to be like, yo, is this bad? A reasonable person would go to a fucking doctor and worry about those babies. They say that they're in the court to look out for the best interests of. I mean, just straight up. You know, and the whole idea, they tried to play this off too. They kept trying to play it off and say, well, there are plenty of people. Yeah, you're using the argument that the plenty of people out there, many of them, they somehow don't know they're pregnant. That happens, for sure. You're in a court, though, saying you're looking out for the best interest of supposed children. That's why you've brought litigation against Clayton Echard. But you just phone it in? I mean, when we say phoning it in, it's not That doesn't mean you did your best, does it? No. And I think that fits here. Petitioner testified November the 14th. She sought OBGYN services from a facility mom doc to determine whether she was allegedly still pregnant. At the appointment, petitioner took 2 pregnancy tests. Both were negative. Petitioner testified she currently weighs 91 pounds but weighed 133 November 2023. During her mom doc appointment, she experienced significant swelling in her abdomen and felt pregnant. Again with the abdomen. Again, she's been eating a lot of mates. Like I said, just like a freaking praying mantis, man. Ooh, my abdomen is swollen. The court was present with videos dated September 19th, 2023, October 9th, 2023. Petitioner sent respondent. I said, postonded. I was about to mix the words. I was like, wait a minute, that doesn't sound right. Of your abdomen as evidence of pregnancy. Dr. Medchill testified that while she appeared pregnant, that alone was not conclusive of pregnancy. Oh, wait, Dr. Medchill said, looking pregnant doesn't make you pregnant. Whoa, wait, didn't Mr. Duty, the Order of Protection guy, didn't he say that made you pregnant? I'll take your word for it. Shit. Huh, weird. Petitioner denies tampering with HCG tests, but does admit to altering and fabricating ultrasounds and sonograms. Oops, that's a bad one. She's like, I didn't mess with the HCG, but the court notes she did admit that she fabricated ultrasounds and sonograms. She further testified that she changed the HCG number on 2 of the results. The court finds little, if any, difference in altering the test itself, for which she denies, and altering the results, which she did tamper with by her own admission. So the court's like, there ain't no difference in what you did. That's the same. A liar is a liar is a liar. Again, court just burned her and called her out. The court, yeah, you admitted to the ultrasound and the sonogram. What's the difference? And also they're saying, yeah, you could have freaking tampered with those too. There is no difference. During petitioner's cross-examination, it became profoundly obvious the petitioner was attempting to coach her answers. David. Oh, man. That's not the good. I love it. Who was the guy saying that other people needed to be punished? Who was the guy that says he follows all the rules in the courtroom? He loved to say that over and over again. He follows every rule to the T. He never violates, never deviates. In fact, that letter that he sent Dave Neal, he loved hammering down on that and saying, he said a couple of times that people have lost their licenses after going up against him, and some have ended up in jail. Huh. Maybe this guy, maybe he needs an about face then. David's sitting on a cruise. He's sweating it too. He's putting up pictures. He's like, I don't really care. I'm sitting here watching his show. Oh, David. It's going to be fun to watch you try to freaking spin away, baby. I'll cover it. I love it, David. You want to come on for an interview? You can come on for an interview. I'll interview you. Other people might not, but I will. I'll let you come on. I'll let you spin your threads and laugh at you the whole time. He'll be like, you can't do that because you might pull out the super chat bacon train. I'll be like, yep, I might do that. Of course I will. And I won't turn off the chat either. I'll let them freaking say whatever they want. Whatever they want. Oh, that'd be so good. Yeah, David, you want to come on, spin your stuff, spin your little threads? Let's do it. You want to have your, what's a nice way for saying lying sack of garbage? Let's just say you're Laura Owens. You want to have her come on too? Come on. Let's all do it. We can have a party. You know? David. You know, you might end up in that Netflix freaking documentary, by the way. They can show you sending hand signals and you acting like a complete and utter buffoon on social media. It's like you've speed run, destroying whatever career and credibility you have. I don't know how much credibility you have. I know that you had to throw away the idea of being a free speech lawyer in order to do what you were doing. All those threats, I'll take away your freaking right to speak, but I'm a free speech lawyer. You had to do all this stupid shit. So yeah, you may end up on a Netflix documentary, just like you always wanted. That's amazing, isn't it? Respondent's counsel identify the issue, move between counsel and the petitioner. From that point forward, the petitioner began to exhibit extreme anxiety and unwillingness to answer questions. Notice that here. So follow this. Listen to how this goes. During cross-examination, coaching, respondent's counsel, identifying that, moved between the counsel and the petitioner. So they block him. They block to make sure no more of that. We see you. We knowed it. We moved in. From that point forward, Laura Owens exhibits extreme anxiety and unwillingness to answer questions. So they're saying she was getting the answers telegraphed. This is bad for you, David. This is very bad for you. The court had to remind petitioner twice that counsel would ask a question and she needed to answer it. At this time, petitioner pushed back her chair and advised the court she did not believe she was being treated fairly. The court attempted to redirect petitioner to no avail. At this time, petitioner became emotional, asked for a brief recess, which the court granted. Again, this went very badly. That recess there, yeah, the court didn't see that as oh, here's a little bit of time to dry your eyes because you're truly upset. Now, the court, if you read that, the court sounds like they might have been a bit annoyed by what you and your client were doing, David. Oh, it's beautiful, isn't it? The court finds this interaction between counsel and petitioner diminishes the credibility and veracity of petitioner's responses during cross-examination. You doing that makes the court question whether or not you might be lying. Wow. The court finds it impossible to determine the date of any alleged miscarriage, not because it is impossible, but rather because she failed to seek even a minimal level of care for a high-risk condition. Failure to demonstrate confirmation, ongoing pregnancy, is a purposeful way to ensure respondent would not be able to determine if she was pregnant, and if so, for how long the pregnancy lasted. Notice that here. The court's like, we can't find a date for the alleged miscarriage, not because it's impossible that there was a miscarriage, but rather because she didn't do anything, no care whatsoever. So, either, which is it? Are you the worst, most absentee piece of garbage out there? Or are you a liar? Failure to demonstrate that, it noted. Again, that was a purposeful way. You did this on purpose to make sure that Clayton Echard would not be able to determine if she was pregnant. She went out of her way to make sure that he couldn't tell, and if so, how long it lasted. So she set out purposefully to do this to Clayton Echard. Dr. Medchill. This stuff is just ferocious. Dr. Medchill, retired OBGYN, prior chair of St. Joseph's Hospital, testified that pregnancy is possible without sexual intercourse. Yes, he's like, the Bible. No, he didn't say that, by the way. He was like, yes, in the 70,000 pregnancies I've seen in the last hour. Dr. Medchill testified that he believed he delivered 30,000 babies. I like that it's going up to 30,000. By the way, that's hilarious. During his practice, and saw many patients for miscarriages. 30,000 babies. We were talking about this with Megan. I was imagining Dr. Medchill standing there with a conveyor, like popping babies back and forth. That is such a funny idea. Medchill testified he reviewed approximately 200 pages of petitioner's medical records from Barrow Neurological Institute in Phoenix that included summaries of petitioner's medications. He did not, however, review primary care or historical OBGYN records. He didn't look at any primary care records or historical OBGYN records. But he did go out of his way to look at certain items. He testified that none of the medications or records he reviewed would cause a false positive home pregnancy test. He testified that a false positive HCG test could be the result of epilepsy medication, anxiety medication, azepam, horse urine, IVF prescribed injections, or trigger shots. When asked by the court, Dr. Medchill testified he did not review any Planned Parenthood records for Mission Viejo or LA. So, oops, she didn't turn those over either that supposedly existed to this expert. Oopsie, they noted that too. Dr. Medchill testified that he is 99.9% sure that she was pregnant based on HCG test. He did not change his perspective after petitioner's admissions on the stand that she altered more than one test to reflect higher viable HCG numbers. This is why, again, I have railed about expert witnesses. It is a joke. It is a nasty joke that you in court have to basically go and get somebody that will counteract them. They should be held liable for the lies that they promote. Because many of these folks, like in this furthered harassment of a victim of a nasty, nasty person. And in many times, they will endanger people or more, and they're never held accountable. The court finds Dr. Medchill's testimony that 0.1% chance that the petitioner received a false positive due to several medications she is in fact taking, possible trigger shots for HCG, and a prior history of ovarian cancer to diminish his credibility. Him saying this diminishes his credibility. This is on record. Him as an expert witness being paid by Laura Owens, he diminished his credibility. As an expert witness, he's done. Because anytime he gets out there, if he goes to another trial, the next trial that he's involved in, every lawyer should be aware that this is here. This portion right here, again, Laura Owens claims another victim. You know, although it's a victim of themselves, but still, she destroyed another life, right? Especially given that records that the petitioner testified existed were not presented to her own expert for review or consideration. Dr. Medchill testified that blood HCG levels of 102 is proof of a non-viable pregnancy, while Dr. Medchill testified that non-viable pregnancy is still pregnancy. The court finds that altering the number to reflect 102,000, which would be a viable pregnancy, to indicate that she intended for the respondent to believe that she was still pregnant with viable fetuses. The court's saying here, you know, her whole, I just sent it to Dave Neal, yeah, that doesn't fly. That doesn't fly at all. Actually, you sent it, and you sent it out to more people. Isn't that amazing? Oopsie. Dr. Medchill concluded that the petitioner became pregnant May 20th, 2023, ended with a spontaneous abortion. Late October, early November, possibly sooner in 2023, given the alterations of the only records to indicate pregnancy, the court does not accept this conclusion. The court's like, no, that didn't happen. The court does not accept the fact that the spontaneous abortion happened. Why? Because she changed the records. Dr. Medchill testified that women may expel tissue during a spontaneous abortion. Pregnancy might remain in the body, ultimately being reabsorbed. Given that the petitioner testified under oath at a prior hearing that she was absolutely 24 weeks pregnant and had seen her doctor, presumably in person, the court does not accept that a 24-week-old twin fetuses would be reabsorbed into the mother's body. The court further finds a miscarriage at that state of pregnancy would result in emergency medical care and corresponding death certificates of the twins. Everything we talked about here. You need death certificates. You would have a medical emergency. There would be record. Something would exist more than this one person that you paid to come in after the fact. If what Dr. Medchill testified to is true, and she miscarried much sooner, negating the need for the death certificates, then petitioner perjured herself at a prior hearing. So either she needed records and did not, she basically broke the law either way, right? She either didn't go through, she didn't get death certificates, or if it happened at an earlier time, which is the way that she's tried to spin it with Dr. Medchill, she perjured herself. She's a liar. Now, Samantha Deans. Now, this is good. There's a few good parts in this, too. Dr. Samantha Deans reviewed petitioner's records and provided her analysis of the HCD's results. Additionally, she was the prior Associate Medical Director of Planned Parenthood in Florida, Pennsylvania. That's a big one right there. Out of anything, again, I find, like I said, experts, they're just basically trying to negate another expert, a guy that was paid for that. The thing that she brought of absolute value to this, in my opinion, though, that you cannot negate it all, is the fact this part right here where she destroys the narrative that's thrown out there. Listen to this. This is monster right here. This is. She testified that Planned Parenthood does not accept anonymous patients. They do not accept patients using an alias. Patients are required to provide a government-issued form of identification. She further testified that Planned Parenthood is not open on Sundays, which petitioner testified she sought care July 2nd, 2023. She lied at every level of it. That's what it's saying right there. She lied about, again, the date that she gave. Planned Parenthood is not open. It is a Sunday. It is closed. That would be in her statement, by the way, because that's not what she said on the stand. Additionally, there are no anonymous patients. We've talked about that a million times, why that is. There's so many. And they don't accept alias. You have to give them government-issued form of ID. Dr. Deans testified, HCD does not confirm pregnancy. There must be serial HCG or an ultrasound and examination, which were never done. Never disclosed to the court, the respondent, Dr. Medchill, or Dr. Deans. Dr. Deans testified July 22nd, 2023, telehealth instructions that petitioner proceed to an emergency room for additional evaluation and care. These instructions were not followed, but petitioner called the abortion and miscarriage hotline, which also recommended and encouraged her to seek in-person medical care. So, she's told twice, telehealth instructions, go to an ER. She calls a hotline. They tell her, go get in-person medical care. She didn't follow any of that. Dr. Deans testified that there is no data to indicate a contraception date. After reviewing the records, Dr. Deans determined that the HCG tests were never positive for pregnancy, and the related miscarriage timeline, which included detailed analysis of likely origin of HCG in petitioner's blood and urine, was not indicative of human gestational norms. She testified that the heterophilic autoimmune responses due to exposure to animals could produce a positive HCG test, but the confirmation blood test would be negative. A prior history of cancer, that could produce it. Petitioner has a prior history of ovarian cancer that prompted the surgical removal of her right ovary. Familial HCG syndrome could also produce false positive HCG. Dr. Deans testified the syndrome is very rare, with only 10 cases in the world. Horse tranquilizers can also. Now the respondent, Clayton Echard. Again, wow. The respondent denies all allegations of sexual intercourse. Respondent confirms both parties were under the influence of marijuana, but denies being high, and further denies memory loss because of marijuana ingestion. He testifies that around May 22nd, he realized his behavior with petitioner was unprofessional, and he intended to discontinue sexual relationship with her. He testified that upon hearing this, she became very emotional. He testified that he told Laura Owens he had submitted the offers to the seller. Respondent testified he did not believe the petitioner was really interested in their properties. When asked if he had received any responses, he told her that he had not, but he never told petitioner the reason why no response had been received, i.e., because the offers had never been submitted. Respondent made knowingly false statements to her about real estate offers. He testified that petitioner sent him approximately 500 text messages. Actually, I think he said 518, but okay, using 13 different phone numbers, threatening to leak information to the media. You know, that right there, yeah. Woo. That's like I said, when you looked at that and I looked at that and we were like, whoa. The judge looked at that and said, whoa, that's worth noting too. Respondent testified that petitioner reached out to the son, called his family, co-workers, prior girlfriends, accusing him of being a deadbeat for not supporting her or twins. Again, calling him a deadbeat dad. But that wasn't good enough. Like I said, life ruination tactics. It's right there. It wasn't enough to call him a deadbeat dad, so she had to go that extra mile and she tried to torpedo his entire life. Respondent testified that he received the video from petitioner and continued to correspond with her over email string, which would reasonably prompt petitioner to advise she did not send the video, but she did not advise of that at the time. So she didn't say, hey, I didn't send that stuff. You know? It's the same string. She didn't say anything like that. Oh, wait, I was hacked or anything. No, it just came up with everything else. That's what she's saying. Well, she didn't say she was hacked or anything. She just kept going. Now listen to this here. This is noted by the judge. Petitioner emailed responded. You can't say you haven't been given a voice when I've told you that I will have an abortion if we try things out for a few weeks and have a good reason for aborting the child. These words feel menacing because you know I like you and want to try things out with you. That's creepy, by the way. That is very stalkery creepy. The email continues. You would be obliging to make the decision to date exclusively before deciding whether or not we have an abortion. The dating contract. Petitioner encouraged respondent to have sexual intercourse with her, citing she was tight and already pregnant. That is going to be there on record forever, by the way. Creepy. Petitioner further emailed respondent the control of the outcome of the pregnancy if we date exclusively and care for one another. On June 28th, she said, if you think about it, having sex with me is the safest thing you can do at this point. I'm already pregnant. And if we chose to go this route and trust each other enough to have sex, then we are at the point where I would be taking abortion pills, so there's no risk. Very creepy. Everything. It gets creepier as you read it through. Petitioner told respondent the twins were a boy and a girl. Petitioner provided respondent with a sonogram that was posted on YouTube 7 years ago. Right there, the judge noted that. Petitioner did indeed provide respondent with a sonogram that was posted 7 years ago. Petitioner admitted to this during her deposition. So she admitted that she provided him with a fake sonogram. Court notes it. Game over. Petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss the action that she initiated. Sent a threatening letter. You notice the statement right there. Petitioner signed a release of records for Dr. Higley at the Women's Care, and the letter dated March 18th, 2024. The provider advised, we have no record of treatment for the date of service you requested. Now, as far as the order of protection, again, a lot of people, when they've talked about this, they were like, well, this is a loss. This is not a loss here because the court is saying we can't actually do anything about this. I don't have the authority. I mean, listen to this here. The court, if you look at everything the court says, oh, they very much would have. They looked for the authority. They looked to see if they could overturn it. They put in the effort. So in this case, Raymond, respondent's position is that petitioner and fabricated her pregnancy, a condition which cannot have resulted from the parties' interactions because according to respondent, they never had sexual intercourse. But he does admit that the pair engaged in oral sex. Respondent seeks to have the protective order invalidated based on the alleged fabrication, while petitioner essentially argues that even if she was never pregnant, the sexual activity between the two, respondent's subsequent harassing online conduct are sufficient to sustain the order regardless. There is predicate issue that should be addressed, which goes to the court's authority to reconsider the protective order at all. Simply put, they name case here, and like cases, precludes reconsideration here. They're saying we don't have the authority. I can't look at this. I can't do it at all. In this, mother applied for a protective order in Phoenix Municipal Court. Is eventually transferred to the Superior Court after father petitioned to establish legal decision-making authority, parenting time, and child support. After a contested hearing, the commissioner handling the order of protection affirmed it in its entirety. Father then filed a special action asking the Court of Appeals to order the family court to amend the order of protection to align it with the temporary parenting time orders it had made in a separate case. The Court of Appeals accepted the special action, finding it raised a purely legal issue of first impression that is of statewide importance, to wit, the interplay between the procedural rules and statutes governing protective orders and family law proceedings. The Court of Appeals first recognized that in the Superior Court, pursuant to, they give the pursuant to here, has the authority to hold a joint hearing to concurrently consider both actions so it may harmonize the orders. But having said that, the court noted that the Superior Court's authority to modify an order of protection only exists pursuant to the statutes and rules controlling protective orders. And those statutes and rules prevented the relief father sought in Vera because another Superior Court officer had already affirmed the contested order of protection. Indeed, the court stated that, quote, once a contested hearing has been held, an affirmed order of protection may be amended or dismissed only in two ways. Number one, by a request of the party protected by the order. So it notes there, how that goes. Quote, because mother had not requested amendment and the father did not appeal from what amounted to a final judgment, he could not obtain relief, and the family court had no power to amend the protective order. Put another way, a Superior Court judicial officer is not to engage in horizontal appellate review of another judicial officer's decision to affirm an order of protection. Holding that a Superior Court judge has no jurisdiction to review or change the judgment of another Superior Court judge when the judgment has become final. Just like in Vera, just like in this, absent a move by petitioner to modify or dismiss the protective order, respondent's sole remedy was to appeal the final ruling affirming it after contested hearing. Now, here's the problem with appeal. Before, if he would have appealed that, we wouldn't have had this decision, and I think it would have been upheld. Now, with the decision, there has to be some way to go after this. I would sue. I would sue the shit out of her for this. Because potentially no legal avenue to remove this thing that she did to me. I would sue her for every penny I could. Clayton Echard should. He should say, after everything that they decided, after the lengths she went to cause him problems with this decision right here. Oh, man. Although Vera did not involve fraud. You notice that. Although it didn't involve fraud. Why would you put that right there? Although it didn't involve fraud. Well, stay tuned, right? Stay tuned. All the best. This court was unable to identify any cases collaterally challenging a final order or protective order judgment on Rule 85 grounds in a separate family court proceeding, nor any authority suggesting that Vera's exclusive roadmap, which is rooted in, they tell again, for amending or dismissing a final order of protection judgment is subject to an exception based on Rule 85 review. The court's power to invalidate the order is foreclosed by Vera. Even if Vera did not foreclose that, respondent cannot prevail here, despite what appears to be a case of serial fabrication here and elsewhere by petitioner. Look at that note there. Look at what the court just said about Laura Owens. Despite what appears to be a case of serial fabrication here and elsewhere. There's two notes there. Serial fabrication in this trial and elsewhere. It appears that she has done this many times in multiple instances. That's not good at all for you, Laura. That's not good for you at all either, David, is it? Oh, man. I mean, that That's a bomb and a half, is it not? Woo, man. Under, again, that the parties admitted having a relationship is previously romantic or sexual, however fleeting it might have been. Petitioner thus had a statutory avenue to seek a protective order regardless of whether she fabricated her pregnancy. Moreover, Commissioner Duty did not issue order based solely or even primarily on the fact of petitioner's pregnancy. Indeed, his initial order requiring that respondent not contact or communicate or post untrue or harassing comments regarding petitioner online, including but not limited to social media, shall not cause others to do the same. Moreover, petitioner's initial petition referenced a myriad of communication respondent made to her that could be deemed threatening per the statutory guidelines and appears to have prompted Commissioner Duty to confirm the order of the hearing. She lied during those, by the way, but hey, let's set that aside, all right? Give me 1 second there. Sorry about that. I had to fix something. I heard a kiddo being like, hey, can I blah, blah, blah. I was like, yeah, don't do that. That's funny. Thus, even if the petitioner's broader pregnancy allegations are proven untrue, one aspect of the court's order indicated that if found respondent had engaged in harassing conduct, so even on the merits, there is no cause to invalidate the final judgment. Yeah, this should have been reviewed and appealed right now. You should have the ability to review and appeal it with everything that's been noted, saying, look, she faked this, she faked that, she's created fake accounts, she's done all of this stuff. So, she could have been very well, quote unquote, harassing herself. Other people she sent this stuff to, so much more evidence. Again, sue the shit out of her in civil court. I would feel so vindicated, but there's no way I would let it sit here. Again, Clayton can do whatever he wants to. I'm not in any way, shape, or form saying that him going this far, it speaks volumes about him. It speaks volumes about his lawyer. Kudos to them. I am glad that you are getting justice, but this is not complete justice in my opinion. Complete justice will be when this person has... Well, it'll be mentioned in a minute. They need police to follow up on it, and more. Bear versus Rogers forecloses not only reviewing the orders in principle, but also prevents tinkering at the margins as well. If the Superior Court cannot engage in horizontal appellant review of another judicial officer's decision to affirm an order of protection, there's no way that the court can otherwise review portions of those decisions piecemeal either. The parties' remedies as to both decisions were to appeal and have the appellate court review the entirety of those decisions. Both had hearings as their respective orders, and under an order of protection, an injunction against harassment, or an injunction against workplace harassment that is entered, affirmed, modified, or quashed after a hearing at which both parties had an opportunity to appeal is appealable. Now, sanctions. Again, under this, it provides by signing a pleading, motion, or other document, the attorney or party certifies to the best of the person's knowledge, information, and belief formed after reasonable inquiry. Number one, it had not been presented for any improper purposes, such as to harass. Number two, the claims, defenses, and other legal contentions are warranted by existing law. 3, factual contentions have evidentiary support, or if specifically, that word did not want, specifically, thank you, specifically so identified, will likely have evidentiary support after a reasonable opportunity to further investigation or discovery. Meanwhile, Rule 26C provides that if a pleading, motion, or other document is signed in violation of this rule, the court, on motion or on its own, may impose on the person who has signed it, a represented party, or both, an appropriate sanction, which may include an order to pay the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including a reasonable attorney's fee. In this case, respondent filed a motion for sanctions pursuant to Rule 26 on January the 3rd, 2024, arguing that petitioner filed the underlying action for an improper purpose without medical evidence to support her claim that she was pregnant and or that she was pregnant by respondent. However, after significant motion practice between parties, attorneys, respondent filed motion to withdraw the motion for sanctions pursuant to Rule 26 on April 3rd, while retaining his other claims under, noting here, the question thus becomes, can the court still award Rule 26 sanctions considering the withdrawal of the response? As already noted above, the court says, yes, I can do it if I want. It says, expressly provides the court can sanction a party for a violation on its own. So the court's like, yeah, I can do it. Hell to the yes, I can sanction you. Baby, you gonna pay. The court was unable to locate any decision pertaining to whether the withdrawal of the party's Rule 26 sanctions precludes sua sponte court award, but as a matter of plain meaning and strict interpretation, it would seem not to matter whether a party ever files a motion or even whether the party does file a motion and withdraws it. A court may still award the sanction it deems appropriate based on the conduct it deems to violate the rule. Indeed, if per Rule 26C, the court can at any time award sanctions of its own accord and on its own finding, absent invitation, the withdrawal of the party's motion to do so would not seem or in any way affect the party's power as a matter of plain logic. So, for instance, if the court were to find that the petitioner fabricated a pregnancy to provide leverage against respondent in order to secure a long-term relationship with him and all of its attendant benefits, did you catch that? Listen to that. So, for instance, let's just say, for example here, if the court were to find that the petitioner fabricated her pregnancy to provide leverage against the respondent in order to secure a long-term relationship with him and all its attendant benefits, Rule 26 would appear without doubt to provide it the authority to order her to pay respondent his reasonable expenses, including a reasonable attorney fees, regardless of any prior filings by the parties. That is because that fabrication, if adjudicated as such, would have been the predicate for her initial petition and many, indeed all, of the motions that came after. Yes, you could be forced to pay if you faked a pregnancy in order to make somebody have a relationship with you, because everything that you base that on is a lie. Everything you filed is a lie. Although there is a dearth of case law on this issue, other rules confirm that the family court has the authority to award sanctions on its own. The given rule here, for instance, provides that in a prejudgment or post-judgment proceeding, the court upon motion or its own initiative may impose sanctions if a party or attorney fails to obey a scheduling or pretrial order, fails to appear at a resolution management conference, a scheduling conference, an evidentiary hearing, a trial, or other scheduling hearing, is substantially unprepared to participate in a conference hearing or trial, fails to participate in good faith in a conference hearing or trial, or in preparing a resolution statement, scheduling statement, or pretrial statement. And the remedies available include, in addition to substantive sanctions, ordering the party to pay reasonable expenses, including attorney fees and assessment of the clerk, or both, caused by noncompliance with a court order. And they give an example here, confirming power of the court to award sanctions on its own. Rule 71 provides for similar power in the settlement and ADR context. Additionally, as is evident from their merely textual identicality, as per Arizona Family Law Rules Handbook, quote, let's see, and Rule 11 also expressly provides that in the event of a violation, quote, the court on motion or on its own may impose on the person who signed it, a representative party, or both, an appropriate sanction. In the Rule 11 context, the Court of Appeal has concluded that a trial court may impose sanctions even after a complaint has been dismissed for lack of prosecution. This lends credence to the idea that the family court's inherent authority to award sanctions under this should not be read to be limited by the course of the case or by litigation strategy pursuant to the parties. The power is there by rule and can be used by the court when necessary and appropriate. Non-paternity. This rule provides a man is presumed to be the father of a child if genetic testing affirms at least a 95% probability of paternity. This provides a man is presumed to be a father based on DNA testing that may only be rebutted by clear and convincing evidence based on a lack of confirmed pregnancy, Rav-Gen results of little to no fetal DNA. The court cannot establish the petitioner was pregnant. The court cannot prove you were ever pregnant. The court cannot establish paternity of a non-confirmed pregnancy lacking DNA evidence despite testing twice. Here, 2 tests of little to no fetal DNA fall woefully short of 95% requirement to meet the burden of a clear and convincing evidence that the respondent was the father of petitioner's alleged pregnancy. So that it falls woefully short of everything. Attorney's fees and costs. Clayton Echard has requested an award of attorney fees and costs. An award of attorney fees and costs governed by provides as follows. A. The court from time to time, after considering the financial resources of both parties and the reasonableness of the positions each party has taken throughout the proceedings, may order a party to pay a reasonable amount to the other party for the cost and expenses of maintaining or defending any proceeding under this chapter, Chapter 4, Article 1 of this title, on request of a party or another court of competent jurisdiction. The court shall make specific findings concerning the portion of any award of fees and expenses that are based on consideration of financial resources, that are based on consideration of reasonableness of positions. The court may make these findings before, during, or after the issuance of a fee award. If the court determines, this is B, that the party filed a petition under one of the following circumstances, the court shall award reasonable costs and attorney fees to the other party. Number 1, the petition was not filed under good faith. Number 2, the petition was not grounded in fact or based in law. Number 3, the petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. C. For the purpose of this section, costs and expenses may include attorney fees, position costs, other reasonableness expenses, as the court finds necessary to the full and proper presentation of the action, including any appeal. D. The court may order all amounts paid directly to the attorney, who may enforce the order in the attorney's name with the same force and effect, and in the same manner as if the order had been made on behalf of any party in the action. So the court finds here there is no substantial disparity of financial resources between the parties. Petitioner did not provide an AFI, but testified she and her mother collectively earned $200,000 a year. She filed an affidavit on May 15th, citing a monthly income of $12,000 and an annual income of $144,000. The court further finds that the petitioner acted unreasonably in this litigation. Specifically, petitioner acted unreasonably when she initiated litigation without basis or merit, without an authentic ultrasound, sonogram, physical examination, or in conjunction with a belief she passed tissue, July 2023, the court finds the underlying petition premature at best. At worst, however, fraudulent and made to incite communication, a relation, or both with the respondent. At best, premature. At worst, you're a liar. The court further finds the filing a motion seeking mediation for the purposes of telling the respondent that the pregnancies were not viable, disingenuous at best, but certainly misleading of the court. Certainly misleading of the court there. If the purpose of the motion was in fact to attend mediation, then the petitioner perjured herself today when she said the purpose of the mediation was to tell the respondent about the miscarriage. Either way, respondent likely incurred costs associated with this litigation prior to retaining counsel, and he's entitled to reimbursement of those costs. The court further finds that petitioner repeatedly failed to comply with Rule 49, even on order of this court, further compounded by the fact that on the day of the trial, she testified that she anonymously sought care at Planned Parenthood in Los Angeles, while she failed to provide records of any Planned Parenthood appointment, anonymous or under alias. Respondent presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, petitioner disclosed she sought care. Up until today. You notice that? Up until today. This undoubtedly caused respondent to incur substantial legal fees attempting to locate records that may or may not exist in LA, but now appear to have never existed in Mission Viejo. Additionally, petitioner acknowledges she altered HEG tests and ultrasound and sonograms. The court further finds that in provisions with, they do apply because the petition was not filed in good faith. The petition was not grounded in fact and based in law. The petition was filed for an improper purpose, such as harassment the other party, to cause an unnecessary delay or to increase the cost of litigation to the other party. Here, the court finds the petitioner provided false testimony as to the viability of the pregnancy in all three cases addressed in the procedural hearing. Right there. The court finds that she provided false testimony as to the viability of the pregnancy. She lied about it in every facet of this trial. Everything. So she is on record lying multiple times about this. Right there. That is damning. That is bad. That is very, very, very bad. Holy crap, lady. Ugh. Man, what a trash fire, Laura. Additionally, prior to her deposition, petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. So this threat that came up again and again, yeah. The court further finds that Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery such that an award of attorney fees and costs is appropriate. So, she knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery. It is therefore ordered granting Clayton Echard reasonable or request for attorney fees and associated costs. It is further ordered denying the fees for the order of protection and the IAH hearing. Because again, remember, they don't have authority over that. So she has to pay all the fees except for the order of protection. Like I said, I would sue the shit out of her. She would pay that, and she would pay a lot more. It is further ordered that Laura Owens shall pay Clayton Echard reasonable attorney fees and costs not later than July 8th, 2024. Respondent and counsel for Clayton Echard shall submit all necessary and appropriate documentation to support an application for an award of attorney fees and costs, including a China doll affidavit in a form a proposed order by no later than July 29th. Laura Owens shall file any written objection in a form of proposed order. If Clayton Echard's counsel fails to submit the documentation by July 8th, no fees or costs will be awarded. So this is laid out there. They're going to lay out exactly how that money is going to be paid, and she's going to end up paying Clayton Echard. If Echard's counsel fails to submit by the 8th, no fees. So, they'll get it in within the month, and bam. The court shall determine the award and enter judgment upon a review of the affidavit, as well as any objections. Additional orders. It is further ordered granting the respondent's petition for non-paternity. Bam! Non-paternity, baby. The court, it has been a long road, but the court has said, not a father. It is further ordered that the court, having determined that Laura Owens has a pattern, listen to this. This is bad for her. Drink this in. It is further ordered that Laura Owens has a pattern of similar, if not identical, behavior and court involvement, referring this matter to the Maricopa County Attorney's Office for review. That's the po-po, baby. The Maricopa County Attorney's Office. Now, people can tag them into posts. They can do whatever they want to say, like, this should be followed up on. And it should, because there are multiple victims here. There's now an article from People. There may be more articles that are based on this too. But right there, again, this has been referred to the attorney's office for review because, like they said, she has a pattern of similar, if not identical, behavior and court involvement. So the court sees what she has done, not just to Clayton, but also to Greg Gillespie and also Mike Mancini. Those men need to contact the Maricopa County Attorney's Office. They need to bring this up, and they need to know what happened to them. The amount of evidence that those men have is staggering. What they need to do is they need to talk to their respective attorneys. They need to make sure everything it's presented in a way where they can engage, they can give a synopsis of what's there, and they can showcase that this person, what they did to Clayton Echard here, what has been noted in this court filing, it happened to them. It happened to them including protective orders. Essentially, she has weaponized this. And they need to put them on fucking blast, too. They need to put this whole system on blast. Because they need to remedy what has happened to people. And they need to do it now. And they need to make sure that there's not a next victim. This should have never been allowed to happen. But it was. This person, they became so brazen about it. They like to brag about their TEDx talks. They had the interviews with different people on YouTube. These folks that, again, they talked about listen and believe and shit. Look what they backed. They backed a life destroyer. When you review this, it's clear. It is, again, her own words in the Mike Mancini thing. Again, her own words say that she went out after he had blocked her off of everything. His sister lives in the area. She sees him in the area and says in the aftermath he's a stalker. But really, she contacts whoever he's around, this woman. Again, I don't know if that's a significant other at the time. I don't know, I don't know if that was a girlfriend or whatever. But finds her, writes her, makes all these terrible allegations. He contacts the police for stalking, and they end up in turn giving her an order of protection because of these allegations that she uses to basically punish people for walking away. The same thing she did to Clayton Echard. She called him an arpist, which the court said there's no proof of that. There's no proof of that whatsoever. She did the same thing to these guys. She was like in the bedroom, kinky sex. Therefore, and the Greg Gillespie stuff. Oh my God, man! All you got to do is read a selection of the text there and all the threats. If you don't do it, then I'm going to accuse you of forcing me to have an abortion against my will, of causing issues or deformities to non-existent babies. I'm going to sue you for this. I mean, yeah, it's just insane. The amount of texts, it's just nuts. Accordingly, it says, the Maricopa County Attorney's Office will be endorsed on this order. So, this will be forwarded to them. The court may decide the amount of attorney's fees and costs to be awarded. Finds there is no just reason for delaying making a final order. It is therefore ordered, pursuant to Rule 78B, Arizona Rules of Family Law Procedure, that this is a final judgment and shall be entered by the clerk. The time for appeal begins upon entry. Of course, they're going to appeal. Of course. For more information on appeals, it is further ordered denying any affirmative relief sought before the date this order is not expressly granted above. So, our order that is available, I mean, they came in fast. When this order came in, I knew. I told Megan Fox this morning. I was like, oh, we were going in. She hit me up. I was like, I'm not looking at anything anybody said or anything else if it's out there. I know, though. I know in my gut what this thing says. I know because of the way that it came in as quickly as it did that it's going to go against Laura Owens. You know it would. You could tell. You could see that. And man, I'm telling you, David there, man, it's fascinating to see what he's, let me make sure he hasn't put up a blog yet. I keep looking to see if he's got a blog. I'm waiting because he says he's going to put up some information about it. Now, there's already articles dropping about this too. So check this out. Let's look at this. This is from People. This came up a few hours ago. Clayton Echard paternity suit. Excuse me. Former Bachelor star scores legal victory as accuser knowingly presented a false claim. A woman filed a lawsuit against the former Bachelor star in September and claimed he'd fathered her unborn twins during a one-night stand. So former Bachelor Clayton Echard has won a legal victory in the paternity suit filed against him 9 months after an unidentified woman, who is named Laura Owens in recent court filings, claimed he had fathered her unborn twins during a one-night stand. The former reality star, 31, alleged during trial, which began June the 10th, that his accuser, quote, had fabricated a pregnancy, a condition which cannot have resulted from the parties' interactions because, according to Echard, they never had sexual intercourse in court documents obtained by People. He sought to have Owens' protective order invalidated based on the alleged fabrication, while Owens essentially argues that even if she was never pregnant, the sexual activity between the two, the respondent's subsequent harassing online conduct, are sufficient to sustain the order regardless. Judge Mata agreed with the former reality star, noting that Owens, quote, knowingly presented a false claim, knowingly violated a court order, compelling disclosure and discovery, according to court documents. Mata found that, quote, Owens acted unreasonably when she initiated litigation without basis or merit, without an authentic ultrasound, sonogram, physical examination, and in conjunction with a belief she passed tissue July 2023, the court finds the underlying petition premature at best, at worst, however fraudulent, and made to incite communication or relationship, or both, with Echard. Clayton. The former reality star consistently granted petition, non-paternity, attorney fees. The court also, quote, determined that Laura Owens has a pattern of similar, if not identical, behavior in court involvement, and referred the matter to the Maricopa County Attorney's Office for further review of the actions. In a statement to People, Echard's attorney Greg Woodnick shared, "This has been an exhausting process, but we are very happy with the outcome and Judge Matta's thoughtful ruling. We hope this will be the end of the saga for all victims." Echard also seemingly reacted to the ruling on social media, writing, "Best day ever." Indeed. Indeed. Best day ever. Straight up, dude. Man, so much awful. Gingras told People that his client plans to appeal the verdict, sharing in a statement, "We are also shocked the ruling came just hours after notifying Judge Matta of our intent to file a notice for change of the judge for cause, citing suspected judicial misconduct. The judge's father was present for the trial, which is not illegal by itself, but raises very serious concerns regarding the judge's neutrality." So, they went after the judge. I told you they fucking would. I made jokes about it. They went after the judge. Oh my God, we're gonna have to talk about this tomorrow. This is gonna be nuts, because this is gonna set off all kinds of shit. They went after the judge. Can you believe that? They filed a notice for change of judge for cause. I want to see that die. I've not seen it. I don't know if it's available yet. Holy God. I mean, that's amazing. If it's available, by the way, mail it to me. I've not seen that. I won't go over it tonight, but I really want to read that. I want to see them going after the judge, because that's really going to make that judge happy. You know, that judge is going to be like, "Oh yeah, my dad, good job, by the way," pointing out their father there and being like, that's not really illegal, but that's misconduct, because that says there's no neutrality. So the judge's father decides to set in to check this out, watches the trial, and that's somehow indicative of them not maintaining neutrality? Are you kidding me? You know? I mean, how often is the father set in? Your parent can't watch you. I mean, what's up with this? This is probably the biggest trial, in that area. They talked about, the cops, all of this other stuff. This is a big deal. So, yeah, I mean, there are all kinds of people there. Yeah. He could have sat at home and watched it on YouTube, I suppose. But he decided to watch it in person. The judge's father was seen socializing with the opposing side and commented that he was here for the shit show. I'm here for the shit show, baby. Oh my God, that's hilarious. He was talking to people, and he said he was here for the shit show. And my client and me, we are a shit show. So I object. We're the biggest shit in this show. Oh my God. I mean, he didn't say, you guys are shit and my daughter's holding the plunger. I mean, he didn't say anything like that, did he? So come on. Oh God, that's hilarious. He's like, my client identifies as shit. Can't say that. Exactly, Sarah. He didn't say, who the shit show was. He just, he went there to well, again, it's a celebrity trial. I mean, you're talking about, again, a guy attached in this courtroom. Lord, how many high-profile trials have gone through? Because it's a high-profile trial. I mean, again, you had media requesting access. You had all those people that wanted to come in and see exactly what's going on. But remember, it's Laura Owen and David Gingras versus everyone else. So after the decision rolls in, they knew it went bad for them. They 100% knew that this went bad for them. David Gingras' own comments let you know that. And really, like I've been saying, one of the things that really tells you that he knew that this stuff was going to go bad, in my opinion, we have been mispronouncing his name from go. And this guy, I mean, you've seen his ego. You saw that email that he sent to Dave Neal talking about how great he was and talking about all this stuff he's been involved in. Not once did he try to be like, my name is Gingras, Not one time. He's called himself douche canoe and the tramp stamp lawyer more than he's corrected people. Like, think about that. More than he's actually tried to get people to know what his real name was. I personally think that that's a statement in of itself. Well, what do I know, right? I do find it very, very funny, though, that he had already been talking about appeals. He was already talking about, we may not win it this way, but, he was talking about a long process here. This isn't going to be decided now. It's going to be decided further down the road, essentially. Man, though, I mean, that. In her finding of fact, Judge Mata acknowledged multiple positive pregnancy tests, including when purchased by Clayton for Laura. Yet she chose to rely on the unlikely 0.1% chance that she was testing positive for other reasons other than pregnancy, the statement concluded. There was no medical basis for the court to find that she wasn't pregnant, but that's what happened. We're confident this decision will be overturned on appeal. Get that dollar. Get that cheddar, baby. I mean, this fucker. Like, think about how disingenuous this guy is. He complains about the super chats, right? He's like, they get the super cheddar, baby. You're taking a paycheck for somebody that lied again and again. You said you'd drop them in a fucking cocaine heartbeat. Like, if they weren't testifying truthfully, if they weren't telling the truth, right? But you made sure that you got that check pressed for you, baby. You made up new rules and conditions. Amazing, isn't it? The decision comes 9 months after the Bachelor alum revealed the results of a paternity test after an unidentified woman filed a lawsuit against him in September, claiming he fathered her unborn twins after a one-night stand. Listen, it's Friday. And you know what we need on a Friday? We need some good news. And who's got the good news today? I got the good news today. He began in an Instagram video. The test results came back early, and they said little to no fetal DNA present. Let's go, baby. I knew that was going to happen, and thankfully 5 months of torture can finally be put to rest. I mean, you look at that statement. This is what got him a protective order against him. That right there. Him saying, look, I've been tortured for 5 months. Oh, fuck you. You can't say that. What? This person put me through hell? And I can't say that? You got to be kidding me. Sue her. They got money. They got horses. They got something, man. They got businesses. You can underwrite them. 2 false accusations in 2 years. I really don't want to. I really don't want to look ahead to the next year to see what will happen. I think 2 false accusations in a lifetime is enough. He continued, seemingly referring to his ex-girlfriend Susie Evans' 2022 infidelity claims. Look, he's so happy too. He's like, I mean, you think about that too. Oh man, poor guy, man. This has been a trying time, but I learned so much about myself, and now back to the regularly scheduled program. I mean, that and false claims about him leaking pictures that were already provided to trash tabloids. The Sun is a trash tabloid. They told me that they wouldn't leak my... Are you kidding me? A trash tabloid like the Sun told you that? I mean, the Sun, to tell you how great the Sun is, the Sun had to pay a man because they falsely identified him as a murderer. They ruined a retired dude's life. Them and a bunch of other tabloids. They got together and falsely identified him not as a suspect, but as a killer, when it found out that that wasn't the case. They also, again, we covered the Depp trial quite a bit, and the Sun, they were the place that went out of their way to call him a wife beater. They took zeal in ruining his life for over half a decade. They took zeal in it. But of course, you know, that they weren't responsible, nor the other people that had access to that. What a bunch of garbage, right? On September the 21st, Echard posted a screenshot of a receipt for a paternity test on his Instagram story in order to clear the air after he was named in a paternity lawsuit in August by an unidentified woman. In the lawsuit, the woman alleged that Clayton got her pregnant after the two met for a one-night stand. After filing the lawsuit, the woman requested Echard take a test to find out the paternity of the unborn twins before she gave birth in February. 33-year-old woman, who chose to remain anonymous, claimed that the former bachelor wasn't complying with the results of the test. Again, calling him a deadbeat. You know, weaponizing in the media. It just meant I got a kid coming this way. Hey, what's up?
Hey.
Hey, what's up? I'm covering a crazy lawsuit. What's up, real quick?
Can I make a TikTok channel about me cooking and stuff? I won't show my face.
No. Here, no.
Okay.
No. Craziness. No.
Why not?
No, because you have no idea what online craziness is like, baby.
Oh.
No. When you get older, you can do something like that, but you know you cannot. There can be none. You can... Oh, Lord, did you hear that? I don't know if you folks heard that. Ugh. That was my oldest daughter. She was like, "Can I make a TikTok channel of me cooking?" I'm like, "No, you cannot." Why not? Because you don't understand like how crazy people are online. You know, you think it's nice because we have the greatest people around, but man. So they see you guys and they think that people are nice. They think that, you know, I mean, again, you know, a little anyway, but even if that were like, I mean, it's just, I hope they never see that side of it. You know, maybe you wouldn't, like as a normal, but, you know, unfortunately, here's another thing. Unfortunately, with covering lawsuits like this, covering Amber Heard, covering the Vic Mignogna stuff, and covering just the insanity that comes out of companies, people are ugly. And, you know, you wouldn't want to subject anybody like kids to that stuff, but I hate that for them too. I've told her, you know, if you want to really do good, what you learn to do, over time as you learn video editing and other stuff, that when you get to that point, you'll be able to do it much better than me, because I'm not skilled at all. Well, bless her there. But this is the timeline. The truth will always set you free. Echard wrote, the email receipt and a post of Instagram stories per screenshot. Television personality paid $725 for a scheduled appointment with a paternity clinic. All those good pictures, man. I have to say, still some of those for thumbnails. I will take my portion of the test on the 27th of September. He wrote in an email, adding that the woman will contribute her sample on October the 2nd. Results will take about a week to get back. I believe we're all on the same page now. At the time, Echard denied claims they had sexual intercourse with the woman. In an interview with The Sun, the woman reportedly told the outlet that he refused to take a test and that she paid $725 deposit, but Echard called her accusations baseless and lacking in merit. In court documents obtained by People, the woman stated that Echard refused to believe she was pregnant when she originally informed him back in June. I wanted you to come over to confirm what I was doubting, and you did confirm that. So I don't see you as a liar anymore. He allegedly texted the unidentified woman. Is that how they ended? What the fuck, dude? Why is that the way you end, by the way? They're so scared. See, this is what I hate about. I find so disingenuous about the media. I was like, is it just in there? You know, they told you about everything, but they ended with that. Why not end about how she alleged that he had done all these terrible things while writing? This is why I don't like outlets that have no idea what's really going on with something. Like if Megan Fox writes an article, she knows this case. Or if she writes on another case, she goes in and looks at court documentation, she talks to people, interviews. They write it really quick, one and done, and they're afraid to really point out anything. They're afraid to do something like a Dave Neal did. They're afraid to stand up and review something and say, hey, after looking at that, therefore, and you know, they wouldn't be afraid to do that if the situation were reversed. If Clayton Echard looked like an absolute monster in this, though, they would 100% stand up and make a proclamation of what kind of a piece of garbage that he was and more. It's just amazing. See, I don't think that's them watching their P's and Q's, as it were. I think a lot of that stuff's deliberate. I think they were afraid to admit that false accusers exist. Because if they do, then it undermines a lot of what they say and report. Give me 1 second here. I'm going to pull up Super Chats. Stuff kills me with that. I get a good laugh out of this stuff, though, because they still have to admit that even with everything, they have to admit that she did lie. They have to admit that she did horrible things. I'm trying to find the freaking Super Chat thing on here, because the Super Chats came in, but the thing on StreamYards is messing up today. Oh, wait, it came back. Oh, never mind. Thank God, man. All right, here we go. Sorry about that. I was looking for the tab on YouTube because they moved it around again, but this came back up. I guess after the problems they had earlier, it fixed it. All right, here we go. I'm going to hit the early ones that came in just because. Let me hit everybody here. AJ Stone, thank you for the 10 gifted memberships again. Thank you, my friend. Appreciate that. I appreciate it sincerely. Thank you. Laura, also thank you for a gifted membership. Again, love those. Appreciate that. Thank you sincerely. Wendy A. asked before, Tug, what about the bogus 911 and FBI? I think you could look at all this as a whole. Again, I hope that when referred to Maricopa County, there needs to be a lot of pressure put on them. They need to understand that the public is watching this, and we know that there was a decision there. Tagging them into social media. Again, people need to go out of their way to make sure that they understand 100% that this, it has been noticed. It has been noticed by a lot of people. Thank you, Mazza, by the way, for pointing this article out. Thank you. I hit that before. I appreciate that. Thank you. Fallen Hero, thank you for that gifted membership, too. Thank you. Appreciate you. Appreciate you being here all the time, too. Like I said. Sandra, thank you for the gifted membership as well. Thank you also for being here. Appreciate you. Shizzy Wiznut, thanks for two. For Yangrus's Venmo, not. Oh, yeah, I need to show you something again. Chris, thanks for the two. Oh, no, McGregor, he's been defeated. Actually, he's been defeated. Oh my God! I wonder how the Conor McGregor of litigation feels about this. Oh yeah, I saw that. He cried foul to the referees. He said the referee was biased. The referee's daddy was watching. Isn't that beautiful? Wendy, thank you. Welcome. Thank you for the membership. Welcome to Tugs Thugs. Appreciate you. Thank you. Edwards, thank you for the two. No statement, but plenty of statement. Thank you. Appreciate you. Rosalind Duke. What's up, Rosalind? Thanks for the 3 months. Deuce Canoe. Rowing up Schitt's Creek without a paddle. I know. It's going to be lovely watching it, isn't it? Creasy, thanks for the 10. Thank you. You and Megan helped so much. Buying Dingus. I appreciate, actually, like I said, all of you folks, like you all help us so much, because so many of you, by the time, I'd heard about this had already been going on. And many of you put in so much time looking into this and seeing what was there. People like the Tramp Stamp Lawyer, they went after you for it too. They tried to call you the JFC crew. Like, what you noticed there wasn't truth. Like, somehow you're just fans. Again, they will minimize you. They will try to make it sound like, I don't care about The Bachelor in any way, shape, or form. I've never cared about the show. But I do care that a guy plus another guy plus another guy plus another guy, they've been targeted by what looks like a serial offender. Courts agree, by the way. And there should be, this, like I said, this right here this will remove her doing talks. It should. If she gets out there and talks about her victim narrative and tries to galvanize support again, because what she says about Mike Mancini or Greg Gillespie, that shit, it can get shut down now, In fact, everybody and their mama should contact TEDx and be like, yo, this person has been convicted of lying about all of that. So as far as your interview here, you actually interviewed a perpetrator and allowed them to go out and to target and re-victimize. Like, that should be called out. Wendy, thanks for the two. How much do you think sanctions will be? We'll find out. We'll find out when all that gets whipped up. It's a lot of money, though. We're talking about a lot of money here. He's racked up 6 figures plus. So she's going to be paying quite a bit of money. She'd be on the hook for quite a bit of money. Wendy also, thanks for the 5. She was hit on the head too many times, falling off horses. Apparently. Actually, it's strange. She found what she thought was a shortcut to forcing people into relationships. She thought she found the ultimate cheat code. You know, it's the creepiest thing I've ever seen. Well, probably maybe not the ever seen, but it goes right up there, you know. And Wendy also thinks for the 5. What about her lawyer? Has no malpractice insurance. That's not good. You know, I mean, the stuff he did. Again, multiple lawyers have said, like, this is sanctionable activity. Like, he's done things that are beyond. And the judge pointed out he was sending signals. The other side had to block that. And after that was blocked, his client freaked out on the stand. Like, that right there is a big deal to note. Like, that is a much bigger deal than I think some people really understand. You know, because, I mean, my God. When have you ever seen something like that happen? You know, not just sending, but, I mean, the judge commenting on it. I mean, like, that had to be stopped. That is bad news. And not to mention, okay, remember the stuff targeting Mike Mancini? Targeting him for arrest? Calling 911? I mean, all of that. There's so many issues at stake here. They could be called out. AJ Stone, additional 10 gifted memberships. Wow, thank you, man. Appreciate that. I appreciate that quite a bit. You know, that's very nice of you. Laura Owens, thanks for the 2. Took him down. Indeed you did, right, Laura? Indeed. Got him. Fallen hero. Thanks for the 2. Welcome back. Thank you. That's after I went out. Again, almost 5 minutes of that. That's funny, you know. That 5 minute there. It's almost like, you know, the delay between Gingrich asking. Okay, so you look at that delay and see how long that delay was in there. Imagine all that time when Gingrich, he posts first person to Venmo me $50, gets the filing, and then he's like, oh, that was a joke, by the way. That length of my delay, like getting knocked off and coming back, that's how long it took him to post. Oh, by the way. Also, I mean, Bits Runner, KMC, Biz Runner. Thanks for the 20 there, Tug. Come back. I know, I was trying hard. I was. And also, Liz, what's up? Thanks for the 23 months. Welcome back. Yay. I know. Man, I was like, no. No. And also, thank you, Liz, for the 5 gifted memberships. Appreciate you too, Liz. Thank you. Oh, what craziness. SF, thanks for the 5. Posted on Megan's local live chat. What AI said. What happened to your stream? Oh no, I'll have to look. Oh no. K-Rap, man, thank you for the $50 super chat too. Thank you, man. Appreciate all of you, man. You folks. I've been very fortunate in being able to, like I say, cover what I want to cover. These trials here. This one should be as big as like a Karen Reed trial. It really should be. I realize that has the state and all these juicy tidbits people have been keeping up with. But, I mean, we're talking about the state has been weaponized repeatedly by a serial offender. This stuff should have been pointed out big time. K-Rap, thanks for the 50 there. We just had an interview with People Magazine where he misquoted a ruling. Judge's finding of facts. He quoted, there was no medical basis for the court to find Laura was not pregnant. He added not, also filed notice to change judge for cause. I know, man. Like, I'm going to drink that in. And tomorrow, I'm sure there will be a lot of fun stuff to talk about with that. I bet you, you know. Like this. This ain't, I mean, this has not ended. That's the fascinating part about it. You know, I have a feeling that we are going to see crazier stuff in a lot of ways. I get this gut feeling because Laura has never, anytime she's had her back against that proverbial wall, she's cried foul and she's gone after multiple people. She's made numerous threats. Again, she's done that through Gingrich while playing, playing the, oh man, this is like Black Mirror. Oh, the O.J. Simpson trial. I'm like Kate Middleton. I mean, good Lord. I don't think we're through. Thank you, there. Orwitz, Feinberg, and Horowitz. Thank you. What's up, man? Thank you for the 10 there. Breadstick money. Get you some. Dude, man. I might even be able to get some dip for those breadsticks. Thank you. K-Rab, also thanks for the vibe there additionally. Garrison's reason for removing the judge is her dad came to watch the shit show. So he's biased. Isn't that amazing? I mean, don't you think that's just... They grasp at any straw. And he's like, that's what attorneys do. Yeah, I hear you, buddy. Larry, thanks for the 5. Haven't had so much fun since Amber Turd. Love the show. Thank you. Yeah, it's been something to watch. I mean, there are so many false accuses. That OnlyFans killer trial. I'm thinking about, they had a pre-trial for her, and then they're going to have a trial. And I thought about watching the pre-trial for that. Going back and tuning into that, because that's an insane trial too. I haven't gone in and just covered like random case here or there, but stuff like that again. She's blaming a deceased party. I mean, she did horrible things, so I thought about looking at that one too. But yeah, I mean, this one, the order that comes in, it feels good to have a judgment go like that. It's sad, though, that so many people's lives had to be ruined, and so much work and money has to be put on the line before you can get vindication. And still, it's not complete vindication yet. Clayton Echard needs to figure out what he can do with the order of protection. And again, you go lawsuit. Oh, God, there's still more, depending on what he wants to do. And again, like I said, when I say this, I want to make it very clear. He's a victim here. I'm in no way, shape, or form saying that whatever he does, he does. When I'm just looking at it, because, I mean, you have to spend more time in court, but she's not going to go away. Like, ultimately, she may be charged, but, she's not going to stop. This has been the way that she's lived for a long time. And Clayton Echard's the one who won. In fact, Clayton, I hope to God you have a security system. I don't mean to be creepy about that or anything, but I hope to God you do. I hope you have a security system, and I hope you stay safe, man. Because people that are unwell, Right, though? Thanks for the 10 there. This is something I really hate about these trials. Justice delivered, but delayed due to jerk attorneys and appeals. Just like yeah, and of course. Just give Clayton his justice already. When will it be over? They'll take it as far as they can, because ultimately they plan on never admitting wrongdoing. Think about this, too. She could have walked away just by saying that she lied. She could have walked away and not paid a dime. But instead, she's going to pay a fortune, and it's not going to be over for a hot minute. They're going to try again every avenue that they can. They went after, again, the judge. They want to put all of that into an appeal push. That's why they worked it in the last minute. They worked it in right before the decision came in. Why? Because they knew that decision was coming. And they put it in there so they can be like, oh, on appeal, this is what we did. Because they knew that trial went bad for them. I mean, anybody. He can say he thought it went good for him, but he knows that thing went bad. Like everybody. He's paid to be in denial. Plus his ego might not let him, say that it went bad. But it was bad. It was a bad trial. Sarah, thanks for the fun there. This is magically delicious, I know. Man, I thought about 30 frosted Lucky Charms freaking jokes. That's gross. Gross. I'm like, no, Tug, you do not make Lucky Charms freaking jokes. Frosted Lucky Charm. None of that. Don't do it. Don't do it. Don't do it. I'm having trouble there. Okay, I'm not going to do it. Also, I love your commentary. It's my fave. Thank you. I appreciate it. Yeah, I have fun. I learned over time, like just, again, some things need to be said. What's been fun to watch in this, to be honest? Dave Neal. I've loved watching Dave Neal and him become like just loud in it. He was like, yeah, I knew they'd never stop on me. So you know what? He drops all nicety there, and just calls out the truth. He's been calling out the truth before, but he got very vocal about it. And I love that about his coverage, He just got sick of the threats. He got sick of them. Again, you think about Laura Owens is so litigious and so nasty. She didn't just go after men with dating contracts. She went after people that she threatened multiple people. Especially, I hate, when I say smaller, I hate saying it in a way that seems negative based on sub-size, but she knew, like, they didn't threaten me. They didn't go after like Megan that established but they didn't go after large channels or larger channels, in the scope of it. They went after people that they thought they could bully into silence. Now Dave Neal was somebody that they had to go after, because he's the point or the tip of the proverbial spear. But the other channels they went after were smaller channels that they thought they could bully into silence. Like if somebody tries to bully me into silence, I have no doubt that I can make enough noise and get together with enough people that I know that we could take it to court and we could have one hell of a show, for sure. But other folks, they don't know. When you're starting out and something's right, and props to the people who stood their ground anyway, but they figured they could probably bully them into silence. And it's the same thing Gingrich tried to do. He tried to directly bully certain people into silence. It's wild to see. I've seen bullying before, but boom, to this level. John, by the way, thanks for the 19 months. That statement by the doctor, and your joke makes me think of the scene from I Love Lucy, where the chocolates are out of control and running on the conveyor. Yeah, indeed. I mean, it is so strange to that. I mean, when people talked about how many, the 20,000 babies, like, how in the world would that ever happen? He would be popping babies out per minute. They should turn that into an Olympic sport. I mean, if he's popping babies out that much, they should, And here's Dr. Medchill. He's on the vertical bars, swinging into the next OR. Look at him go. Look at the style. Oh, look. He's going with the over-the-back delivery slap. Oh, we've never seen this one. I mean, could you imagine that? That would be amazing. That would be something else. Thank you. Froggy Girl. What's up, Froggy Girl? Thank you for the 23 months. Oh, I need to watch the beginning on replay. I hope she gets what she deserves. Oh, yeah. It's frustrating to see people get away with stuff like this. Thanks, Doug. You're going to... Oh, you'll feel good about this one. Laura Owens. Thanks for the 5 there. So you're saying maybe I should have used an attorney with actual family law experience? Well, I ran out of those. Indeed. I never thought that that lawyers came by the baker's dozen. You know, many things come by baker's dozens, but I never really thought about that. And, you know, and lawyers going out and trying to get justice. He came at me, Red Queen. Thanks for the 10 there. Hate the douche canoe. Using magazine-style publicity to try to get public sympathy for lawyer and a chance of appeal and to avoid criminal charges. Mostly, I'm sure. Yeah, that's... He's trying. I don't think he's been very effective with it, though. It's like I've said, if this got big enough, you would have... There's an element out there that they just, for whatever reason, either be contrarian, or they hate men, or they don't want to believe in false allegation, or they don't want to admit it, or just whatever. There would be this fringe element, but it would be pretty small. And with a decision in, it's going to be difficult to go out and try to convince people. Oh, well, especially with everything there. Sue Scott, thanks for the 5 there. Here's a statement to people. Now blaming Matta's father. I know. It was funny, though. I made jokes saying, wait until it goes after the judge. You know, I was joking about that on after the trial. Like when we were doing trial coverage, you know, in the... when we actually went over and looked at everything. And sure enough... I mean, that's wild. Like just throwing darts everywhere and hoping that you can puncture someone's career. It's craziness. K-Rap, thanks for the rhyme there. There's something here because Tilted Lawyer is talking to Mike. That's interesting. Yeah, you know, I'm fine with talking to... Again, I'm not a lawyer, but what really interests me and stuff like... First of all, I'm interested in cases like this, period. But what really interests me here, too, is public perception of who is a victim of Laura Owen, who's a survivor in this. I mean, you think about when Mike talks about the damage that this has done to his life. I mean, really think about that. Like, he's never been able to move on with his life. That's the thing with victimizers. They never let you move on with your life. They do nasty stuff. They don't worry about court decisions. They'll do everything they can to harass. They'll break it. People like that, they rarely ever face any charges. On the other side, though, if like a Mike Baroncini, you know, or a Greg Gillespie were to violate, or to be perceived as violating, God knows what happens to them. You know, like Greg, I understand like why he would be reluctant to discuss things himself publicly. I get that. I'd be curious to talk to him, you know, just to... I'm sure there's pieces of this that I'm not seeing. You know, like certain perspectives that he could probably shine a light on. I'd be curious to talk to him about that in an off-the-record capacity. But I'm hoping one day he gets to talk about his stuff publicly. Because he deserves to. He deserves to be able to. Laura B, thanks for the 20 months there, Tug. Laura Owens cries with vocal cry. Like, totally. I wonder if that happens. Each tier comes with a totally. Ugh. Well, Heather, thanks for the 2. 1.4 million for a lawsuit sounds right. Yep. I mean, she set the bar, right? Sue her for $1.4 million. I mean, why not? That's what she thought was fair. So, Mystery Sky, thank you. Welcome. Thank you for the membership. Welcome to Doug's Thugs. Appreciate you. Thank you for that. Right, thanks for the 10 there. Judge's father didn't say that. He said he was there for the circus. That was Megan's translation. You know what that tells you? That even though Gingras says he's not listening to people, he absolutely was there. Isn't it fascinating? He's like, I can't even remember Megan's name. You remember the email that he wrote, like that mega cult wannabe, when he's talking about Megan. And yet, he would be using her description of what happened. That's even better, isn't it? That's really, I'm telling you. That's really going to piss that judge off. Oh. You know, that was a real smart thing to do, too, right before you get sanctioned, right? Right before the attorney fees and requests come in. Hey, why not make a statement that takes aim at her father? That's surely going to make that decision come out in your favor and Laura's, right, buddy? Good job. I mean, he's got to be the dumbest fucking human being on earth. I mean, my God. Like, it didn't take aim. Like, I really think about that. Didn't take aim at just the judge, but took aim at the judge's father when she's got to decide on how much money. Like, if I were, again, not taking any pressure off of Laura Owens, because she did this all to herself. But my God, if this dude were my lawyer, like, I'll be like, well, something, the septic system must be backed up because I know I would flush that bullshit. I'd flush that fast. So, I mean, that's wild. It is, for sure. We're like, are you making those kind of statements right before I have to find out how much money I got to pay this other person? You want to motivate the judge to do what? Maybe motivate the judge to follow up with Maricopa County and to see, like, if they, I don't know, would follow through. Because I'm sure that if a judge was like, hey, I wanted to check up and see if you actually did what I recommended. I mean, we talk about all this stuff. Judges, just like anyone else, are human. And if you were to put a crosshair on their families, as a person, Laura Owens has done that. Like Echard said, not just went after him, but contacted family as well. Yeah. That might look like a pattern of behavior there. A pattern of behavior that, again, you're biting off a lot more than you can chew. And as a lawyer doing that, who has done sanctionable things, according to multiple lawyers, maybe you shouldn't pick that fight with that judge, because that's how you lose. Again, people will be like, well, judges are human. That's why, like I said, in my own backyard, I criticize the shit out of law enforcement and everything else everywhere else, but here, everyone's great. Yeah, you don't do. You should know better. Heather, thanks for the 2. Again, like JD, they make claims and try bullshit tactics. Of course. Of course they do, because they're hoping, again, they try to, just like any of these other cases too, they try to weaponize not just survivors, but women women that have gone through horrible things. They're like, hey, it's part of the sisterhood. And it's so despicable. You know, their tactics. When you look at the earlier statements made by Laura, again, she tried to go after Clayton Echard as a deadbeat dad. Because Clayton, behind the scenes, when you look at what was really happening, he questioned the legitimacy of a pregnancy at all. He didn't say, I won't do anything if this is my child, if there really was one. He questioned the legitimacy of the claims made by one Laura Owens, because he knew that they had not had penetrative sex. But the media, when they picked it up, they picked up that talking point. It's sad. It is. And they use this bullshit tags. You're right. Sue Scott, thanks for the 2. Yeah, really. Get that bank is what it is. Get that party on, Clayton. Actually, Clayton, you know, props to you, buddy. Props to it. I'm happy for him. I am. I know a lot of people are. I am glad for him, though. Wendy, thanks for that. Oh my God. This dude is an absolute tool. He is, and he's crazy. He's my favorite lawyer, though. I am going to say. I would never let him represent me in anything, but he is my favorite lawyer. Like, you tell me a lawyer that's out of any lawyer that you want to watch in the shit show, you've got to admit, like, he's a fun one to watch. You know, again, everything he predicts is wrong, too. So this one, like, I love this. You see all the comments coming in. And he's trying to pretend like none of this is bothering him. You know, I want to show you those in a minute. But my favorite, because his predictions have been so off. Yo, he's got if the DA charges your client, well, you represent her in that case, too. The DA isn't going to charge anyone. His predictions have been so bad so far. That's great stuff. But look at this. It doesn't bother me. Look, I'm watching this show. I'm on the fun quest, baby. He's like, I'm not worried about the ruling. I'll release a longer statement later. For now, I'm on a boat and I'm having a lovely holiday. Just posted this on another reply. But here's a live pic watching a goofy show thing, ruling in hand. Yeah, I'm so unbothered by it that while I'm one of the... I managed to sit down in front of this show where there's no one else that actually seems to give a crap about it. Look, nobody else is watching it. Yeah, well, there's one person. It doesn't seem like anyone else is invested. But he's like, look at me. I'm actually quite casual. I just got this ruling in my hand on my vacation, reading through it. Triggered. And he's like, you think I'm mad? I'm on a boat in Italy. Angry levels is literally 0. I'm disappointed that the court system isn't perfect, but we already knew that. This is why I get out of bed in the morning, to fix mistakes and to protect the law. Live pic with ruling in hand. Oh my God. Well, let's see some more. Hey, bud, your comment to the court was misleading. Cruise ships have Wi-Fi. We've all been on a cruise. The lawyer's not special. He's like, oh, it's my connection. Somebody was like, hey, your comment. well, it's my connection. My connection, though, it's not bad. It's like, wait a minute. What are you trying to say? I'd say stick to being a lawyer, but it appears you're equally as bad at that as you are at comedy. Oh my God. If you think if a judge makes a mistake, that proves I'm a bad lawyer, how special. Do you want me to link to a recent ruling where matter was reversed on appeal? Want to bet that'll happen again? I mean, he's going after matter publicly. Repeatedly. So he did that here too. Now, I'll explain more later. Enjoy your cult. People are like, ah, you suck. He's like, enjoy the cult. You know, he keeps whining, too, about nicety. Like, people are like, you know, you're nice? He's like, yeah. You can see where he posted stuff, you know, like, you regularly said, just ask nicely and I'll post. I know, but my kindness in that regard has not been well received. And then somebody was like, what kindness have you shown? You've lied. You've said horrible things about others covering this. You're not dumb. You know Laura was lying, just like the billion before you did. Hence, she couldn't keep a lawyer. Then you came along. So friendly. I mean, isn't that funny? And he did one other. Let me see. Where's that other? Did he pull down the... Oh, this one. This was the quieting the witness. This is what he's saying about his hand movements. Now, he posted this before the judgment came in. But he posted this to try to deflect against his hand movements. He said, many people don't know this, but to preserve or present objections at trial, a lawyer is always allowed to interrupt a witness verbally or with gesture. It's called quieting the witness. This practice is not just allowed and proper, it's required to preserve objections. So he's like, I was just quieting the witness. I wasn't sending her baseball. You know, isn't that amazing? Good times, man. That's some fun times there. Let's see. Did I catch that? Yeah, I got that one. Thank you again, Wendy. Box for Life. Thanks for the 10 there. Can an appeal delay the sanction payment? Yes. It'll delay the payment. They can delay all kinds of stuff. I got another little one coming. Hey, what you doing? I don't do that. That's not good, okay?
Ow, my foot.
Oh, here's a kiss for you. Here, I'll blow it to you. Here, hey. Did you hit it on something? Mwah. Rub that on there. Mwah. Here's the next one. Rub that one on there too. Rub them on. Rub that on there so good. Is that good? Yeah, does that help now? All right. Hey, I'm almost done. You want to watch some show in a minute?
Yeah.
Okay. I'll be done in a minute.
Some popcorn.
Popcorn too? Maybe. Go see if we have some popcorn. Go find out. Is Sissy up there? Okay, well, we'll see if we have popcorn. Okay. John S. thinks about resounding defeat doesn't stop the monsters. Look at AH. That is very true. That's what I'm saying. They never stop, man. But at least you win, you know. Zoe, thanks for the month there. Oh, the appeal make her look to attorney's office. That's true, too. Yep. Okay, thanks for that. Tug. Do you know the song She's Tight? Yeah, by Cheap Trick. Yeah, I have not played. Check it out on stream if possible. I do. They'll hit the live stream. They may knock us offline for playing it, though. I do know it. They're not nice about allowing us to do that. But yes, I do know it. All right. Well, we've hit the end of this one. And it is it's been an interesting one, I have to say. There will be more tomorrow, I am sure. There'll be some, Lord knows what'll come up about this, too. Let me find a song.
I like songs.
You like songs?
Yeah, dance with them.
You like songs?
Yeah.
You like singing songs or listening to songs?
I like songs.
You like listening to them? All right, well, I'm going to play a song. I'm going to see people out. Appreciate you, folks.
Go.
An army of one. Peace up, walk by, verbal clips, and they done. Yeah, stronger than the tide. I'm the wave maker. When it comes to false accusers, I'm the claim breaker. They wanna rack me up. When it comes to false accusers, I'm the claim breaker. They wanna wreck me, but I'm not backing down. Rolling through their hoods, bumping my own sound. Monetize the haters, raining ice and platinum grills. Pure determination, dropping these mic skills. That umbrella guy, family in the web, crushing keyboard jockeys with all my verbal clips. You wanna break me, but still I'm standing tall and only you want conquering them all. Conquering them all. Conquering them all. on like fleas. That umbrella guy, no, we're not playing. They ruin lives that should be paid. They really thought they could treat us like cattle. Ownership papers and roundups like chattel. That umbrella guy, an army of one. Step up, walk by, tell them they're done. It's not enough to laugh when we select them. We gotta stand strong and wreck them. That umbrella guy, an army of one. Step up, walk by, tell them they're done. Enough to laugh when we select them. We gotta stand strong and wreck them. So you want us to separate your heart from the artist? Now that umbrella guy bumps the hardest. And then we learn to forgive and forget. No, that umbrella guy ain't your pet. They wanna grind us down and keep us beneath. But there's platinum grill, that's some iced out teeth. With verbal clips that'll do more than bite you. That umbrella guy crushing it just to spite you. We gotta remind them that we're standing strong, growing by millions as we all sing along. And ignoring the media slander that they blast up. Because that umbrella guy serves no master. For sure they'll take aim at our lives, but we're like lions being swarmed on by